For entering impairment, present appellant elder father अजून checked नाही. Appellant elder father death on dated for 300. छुट्टी मतलब no छुट्टी दी दिन पड़ जाती. छुट्टी दी दिन पड़ जाती. You can you obtain instruction? I'll try to do it. English for it after lunch.
The Lordship's kind permission. My land acquisition matter, where my lord on the first day, even when the matter was being taken up for fresh admission, the state filed a counter. Therefore, the Honorable Court was pleased to post it for hearing, and no interim application was not dealt with. Then the matter was listed for this Honorable Bench on 5/11/2024, when the State Council sought for time on the ground that they have been newly inducted. So your Lordship was pleased to direct the matter to be listed on 18/11, week commencing 18/11/2024. Now the matter has not come thereafter, and now they are proceeding. Therefore, my lord, I am mentioning for your Lordship's kind concern.
My lord, the Contempt Energy Authority is going to, by violating this order, this order, my lord, is going to evict my lord. Contempt matter, my lord. It is related posted on 17 to my lord, but not listed, my lord.
17
to
appeal.
No, land acquisition matter, my lord.
All right.
This is land acquisition and compensation matter, my lord. It was ready for hearing. Earlier listed before the Honorable PIL bench.
The appellant is in more than 12 years of please give it. Second person, the petition, press admission.
Criminal appeal, the appellant has undergone 17 years of custody.
Please give it.
On previous two occasions, this bench had granted him interim.
Please give it.
Deprivation.
Item number 1.
My lord, here my lord, petition challenging the order of arbiter, my lord. The dismissed my petition on the ground of limitation. Earlier, the petition up to this court, and this court directed to file a petition before the arbitrator and collector, and that is the order passed by this court earlier. Earlier, that is my lord, in that is observed my in that.
But the authority has rightly said that this court, while passing the direction, had not taken the limitation. The court gave you opportunity to approach the authority.
So that's all that 3G5 opportunity then what order was passed in terms of this order? That is annex of 5 matters. Yeah. And on the ground of limitation that was rejected
Page 34 my lord, will kindly come to the last paragraph.
Last paragraph.
Page 34 last paragraph.
It is appears from the order of this court. But the question of limitation was not raised, nor any decision was taken by the honorable court to condone the delay. The petition intentionally deliberately suppressed the matters. That's rejected. What is the period of limitation? That is the 2 years, my lord.
3 years.
3 years.
That is 17 is 2017 is the date, but 19 my lord filed at least.
You filed it after 2 years, beyond the period of limitation. So period of limitation is 3 years. You filed it in after 5 years.
In fact, my lord, same page 34, the third subparagraph. There is clear. Admittedly, the petitioner did not submit any petition under Section 5B Limitation Act 1963
before this tribunal to condone the delay. And in alternation, in para 9 of the statement of argument, the learned advocate for the petitioner submitted as follows: that as because the statutory period of 4 weeks is granted by the Honorable High Court to file the present petition, and no condonation petition is required to be filed.
Where from it is?
And on that premise, he has gone ahead and he has dismissed it because no petition has been filed.
But this is being submitted by the advocate.
That's not the revelation of violation. Well, let me limitation petition.
No, but in any case, you have to justify the delay. You are still not filing the. You are not explaining that.
Actually, let me reminded. I filed a limitation before petition there, and that may be my lord.
The provision limitation act is applicable or not?
Yes, my lord.
So if it is applicable, why then to file the limitation petition?
Not taken, my lord, but done. Put below, my lord.
He was under the mistaken impression that my lords have condoned the delay. That has not happened, my lord.
It was just a representation disposed of, nothing more than. Who are to be heard in this matter apart from the state? NHI, who is to appear? Mr. Amitabh Das or?
They have a panel, my lord.
Okay, then let us give notice to the. That would be. All right. This writ petition has been filed by the petitioner Namita Sahu, challenging the order dated 17/10/2023, passed by the arbitrator cum collector Tenkana, opposite party number 4. In rejecting the petition filed by the petitioner. What was prayed for in that petition?
For evaluation of my that
Revaluation
revaluation
of the award passed on the ground that it is barred by law of limitation, and accordingly the same was rejected. The land counsel for the petitioner submitted that earlier the petitioner approved this court in WPC number 22534 of 2019, which was disposed of on 7/1/2020. And it was observed that the petitioner, if so advised, can raise her claim before the opposite party number in view of section 3G(5) of National Highways Act 1956. And if such an application is filed within a period of 4 weeks, then the opposite party number 4 shall dispose of the same after giving opportunity of hearing to the petitioner as expeditiously as possible. The land counsel argued that in view of such order passed by this court, the petitioner moved the opposite party number 4, but no limitation petition was filed, as the petitioner was under impression that in view of the order passed by this court in the aforesaid petition, the this honorable court has condoned the delay, and the matter we now would be taken up on merits. The land counsel for the petitioner submits that if the matter is remanded back, then appropriate application for condonation of delay would be filed for the consideration of the opposite party number 4. Otherwise, the petitioner would be seriously prejudiced. Issue notice on the question of admission indicating therein that the matter to be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite party number 1, 4, and 5.
5, my lord.
One and
What is
five.
the arbitrators?
1
And 5.
1 and 5. So far as the opposite parties number 2, 3, 4 are concerned, requisites for issuance of notice by speed post we filed within a week, and matter will be listed after 4 weeks. Count affidavit can be filed in the manifest. Yes, it also the order copy file which is taken on the court again.
May I please? My lord,
So here instruction was to be taken by from the
My lord. But assessment, my lord, has not yet been done. That's the instruction they have received.
sub-collector was to get the assessment, no?
My
Measurement and assessment.
assessment.
So there was a stipulated time for that from the side of collector.
They say that they anticipated some law and order issues, so although the team was ready, they could not contribute. Must have been opposition, my lords, that's why.
But then
My lords, direct, my lord, that can be done within a period of 3 weeks. Seconds of CORAM.
my lord,
Just a minute. So what do you say now?
If my lords may direct in 3 months, they will do the needful. I think I'll discuss with them and I'll get it.
You want the matter to be adjourned for
My
3
lord.
months?
the direction to
Or
be
my lord,
completed within certain period.
Dispose it of my lord, saying that within 3 months they should
Yes,
carry
yes,
out
that
the
is.
no, my lord. The issue is different. Disposal, let the file, let the take instruction. But the issue is, they are disputing, they are saying in their input letter under Annex 5 that post 9-1 structures, they are not doing this work of measurement and assessment because of, they are saying that it is all post 9-1 structures. Therefore, my lord, let them file the counter whether we are entitled or not. Matter will be decided on merit. The disposal will not be solve the problem.
The in that just previous paragraph
Ma'am.
of the last order, his submission was recorded that the structure is still in existence and till date no assessment and measurement has been made in accordance with law.
Ma'am.
And if without such assessment and measurement demolition takes place, then the petitioner will be deprived of getting the RR policy, because your
Ma'am.
RR policy is there that if the structure is there, all these things, then
Ma'am.
what is to be done? So now, if you take the steps and after proper assessment
Ma'am.
and measurement, if you demolish it, then everything will be on record, and so that is why he submits that let it be this disposal.
Then my
Definitely would reduce one case, but whether he will get any benefit or he may similarly situated person should be there in that locality whose structures should be there, and they are entitled to get the compensation. So you have taken a decision already.
But one thing, Mr. Counsel, the dispute is with regard to the raising of the construction. after 9-1.
My
Is
lord,
it not? So
There-
they are saying. You say that construction was already there.
my lord.
So in any case, acquisition has to be there. The question of compensation has to be.
And also the RR benefit.
Is it not? RR benefit. That is more important for.
Important is RR benefit.
So once the measurement and assessment is done, and it is, as my senior is also telling, that once it is on record, the question will be RR policy or the compensation is to be paid or not. That will be on black and white.
Let the undertake to pay the RR policy benefit.
No, that they can.
They are now my learned friend is saying how they are entitled.
No, you see, suppose in a particular patch, there are 50 plots. In 50 plots, there may be structure on 10 plots.
97 plots are there.
We do not know. That is why we are not entering all to this. Once they will take the measurement and ascertain that whose plot it is, in whose name this plot is recorded, kata is recorded, and what is the structure. So all these things, detail would be taken, then demolition takes place, then the question would be considered whether any of you comes to or entitled to get that RR benefit or not, as per the scheme of the government. So that is why they are asking now some time to do it.
What I pray, my lord, let the matter be pending. Let them take instruction and file affidavit.
All right, let's on. As per the order dated 4/2/2025, the Land Council for the state has produced the written instruction dated 14/2/2024 from the Sub-Collector Talche, wherein it is stated that with reference to the order dated 4/2/2025 of this court, the collector and district magistrate on board issued a letter regarding demolition of honeycomb structures existing on the land acquired by MCL in various locations of Talche coal fields. As per the request letter of General Manager Jagannath Area MCL dated 18/11/2024. Stop. As per the order of the collector and district magistrate on board, though measurement and assessment was planned to be taken up as per rules, the same could not be carried out due to law and order issue. It is further stated that any coercive action would be taken after the impending RPDAC meeting and after due assessment and necessary compliance with the existing law. The Land Council for the state 3 months adjournment to apprise this court about the development made in the meantime. Put up this matter. After you it is expected that if after the RPDAC meeting, the decision is taken to demolish the honeycomb structure existing on the land acquired by MCL, not only the petitioner, but others shall cooperate so that it can be expedited and the authority be in a position for assessment and necessary compliance with the existing law.
If the structures will go, then they should also take steps for RR policy.
In accordance with law, ta mane kon? Hala? Yes,
ନା ତାଙ୍କୁ ମାଗନ୍ତୁ
copy of the order.
ମାଗନ୍ତୁ ସେଇଟା
Item 3.
Fine. Annex 6 is finding opposite part number 2. Similar type of matter to the decision. Correction copies.
The petitioner has submitted or somebody else? How many names are there?
Villagers.
Oh, but this petition has been filed by only one, Harish Chandra Mohanta.
Again.
Where is his name?
He is not there.
As for representations, enter villagers are.
No.
But at least he should be there. No, where is he?
अरे जी आसीची एठी तार रिप्रेजेंटेशन ना नथियो आपण गां लोक जाने
ତାଙ୍କ ନାଁ ଅଛି
20 mail out में kindly on the
Oh,
last
Harish Chandra, last one.
Harish Chandra Mohan.
Last one is there.
से कहू ना आपण
He should, at least he should be one of the. Harish.
ए सब ठीक अछि तो
ଆଜ୍ଞା ସବୁ ଠିକ ଅଛି।
माने बारीपदा जोन
आज्ञा।
अपोजिट पार्टी नंबर 2
ଆଜ୍ଞା ଠିକ
हां
ଅଛି
सब ठीक अछि तो
ଆଜ୍ଞା
ए सब मैटर उडा से
ଆଜ୍ଞା correct ଅଛି
हां
लिखी दी.
आ दूसरी जा करेक्शन हो लिख दी जन
आज्ञा
ओ नियो आपण ना लिखि दियंतु
आज्ञा
Item 4.
Contempt petition has been filed for non-compliance of the audited. Which order has not been complied with? Annexure 1, my lord. Annexure 1? Yes, my lord. Order dated 29/4/2024.
So you moved another recommendation.
My lord, I filed a reminder. What reminder? Communicating the order passed by this honorable court. Also resubmitting the documents that were already before that. No, the order was very clear that the representation which was pending with the authorities, that is to be disposed of, and that representation copies annexure 13. Yes, madam. If you file a fresh representation, then how it would be a contempt, because you have if some more things might have been given, more documents, etc.
Or additional facts.
I just communicated, the petitioner just communicated the order passed by this honorable.
No, then what is Annexure 2?
Annexure 2 is that communication. The
That communication is a detailed one.
It runs to 5 pages. Yes, madam. It may be so that some additional fact might have been stated here. Well, all the documents which were before the authority, along with the certified, the certified copy of the order dated 29. If you have not submitted, you could have filed another petition and annexing. You say, suppose you are missing some, that is a different matter. But by the way, so far as this order is concerned, 24. What is that order? 29/4/2024. So that you just take instruction whether the representation has been just pass the order and communicate. So when will take up this?
2 weeks. 2 weeks.
2 weeks, all right. This contempt application has been filed for non-compliance of the order dated 29/4/2024, passed by this court in WPC number 10053 of 2024, wherein direction was issued to the opposite party number 1, Commissioner cum Secretary, School and Mass Education, Lok Sabha Bhavan, Bhubaneswar, to consider and dispose of the representation filed by the petitioners under Annexure 13 to that writ petition and to pass appropriate order as early as possible within a period of 3 months from the date of production of the certified copy of the order. When you produce the certified copy?
On
Where have you stated?
that is, my lord, annexure 2. On 2nd May, I submitted the certified copy.
Representation
Yes, certified copy. Yes, on 2nd of May.
So if some additional fact is also mentioned in that representation, how can it be taken?
We cannot.
Why are you not become?
My lord, without looking at the representation, my lord,
All right, the learned counsel for the petitioner submitted that the order copy has been served on the concerned authority on
2/5/2024.
2025, but the order has not yet been carried out.
24.
24. The learned additional government advocate 2 weeks time to obtain instruction regarding the status of representation filed by the petitioners. Put up this matter. 2 सप्ताह है आज हला 24. So let us 3-10 को skip over कर दी 17 तारीख रखी दो.
Okay.
Item 5.
Similar matter.
Similar.
And office dealing with similarly representation was to be disposed of. They haven't yet disposed.
अच्छा. ସେଇଟା ଏକ ଦେଖିବେ 17-10 ରେ ଆସି 17-3 ରେ ଆସିବ 2025 ହଁ ଆଦିରେ ରିଟ୍ ପିଟିସନ ନମ୍ବର ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଗୁଡା ସବୁ ଦେଖିବେ. Yes.
Item 6.
Yes.
And the last occasion, with the observation of the Honorable Court,
ये last order to the
the reputation has been filed by the petitioner.
Just a minute. Cannot be hard here. But it must be a problem. That is now. Division bench where so it will be listed next week because Honorable Justice Rotho is not there today, and this the acting Chief Justice my note or noting is that it should be heard by a division bench in which she is a member, right? So put up this matter next week. Yes.
Item 7.
Please, Your Lordship. My lords, item 7 is a covered up measure.
28.
28.
एरा सब करेक्शन कर दी चंदी.
Yes, ma'am.
हमने पोर्टल का हाउ सब ठीक ठाक अछि.
Again.
एलआर केस नंबर टा कोन चेंज करना दिस क्लियर होई छी.
Same.
Same earlier. Yes.
माने ए जो ताऊ परे पूर्वरु जोटा थिला एलआर 50 ऑफ 2012
दुईटा with matter तीनटा
सब से ऑर्डर.
Yes, ma'am.
So we can not change it. But you can change it.
Item 8.
May please Lordships. My lord, this is second round litigation. Petitioner seeks employment on the MCL as an land house to my lords. Your Lordship had annexure 11. Your Lordship directed to file a detailed representation that will be considered by the authority, my lords. In the earlier occasion, my lords. That is annexure 12, my representation. Annexure 13 is the rejection. So, may notice may be issued, my lords. He is only 22 years.
Why it was rejected? Just
annexure 13, my lords.
No, you see the reasoning.
The reasoning for rejection
Yes, my lord. All the reasons I have categorically mentioned in the writ petition are not germane to the issue, my lords. And my lords, the petitioner father, my lord, the grandfather is the land house, my lords. He annexure 1 is the khatian, 2 is the notice to receive compensation, my lords. Then, my lords, Dilip Behra, who is the
Mr.
father.
Mishra, there is a question of adoption. The very
Yes, question of adoption. But
so this has to be a declaration from the civil court. In absence of that, your age, your name, everything is different. How can it be?
That deed is there.
You need to. You are saying that give and take has taken place. So all these matters have to be taken in the civil court for a declaration. Only after that the authority can pay you. In absence of that, your age is not that. Your father's name is different. Everything.
I pray, my lord's employment. I don't. I'm not.
Whatever.
Employment means if you are adopted according to
your case.
Your lordship to consider. Let them come, my lords. I'll take notice, my lord. You're subject to your lordship.
Why?
No. What is the?
My lords, may kindly come to paragraph. I've mentioned in paragraph 15, 16. I thought it will be.
You just start from E, clause E of the order. Subsequently, the petitioner has submitted a copy of the deed of adoption executed before the registration officer Talcher, and you proceed thereafter.
For that reason, your lordship may kindly come to paragraph 19 of my writ petition. I've narrated everything, my lords, in paragraph 19.
No, but is it a conclusion that the authority has to do at this stage?
My lord, you may kindly come to paragraph 19.
19.
Clarify the question. That will clarify.
All right. 19.
Page 9, paragraph 19. That the finding, my lords, got it? That the finding of opposite party number 2 in detail number A of annexure 13 is that Bilu Behra, who died on 31/5/2018, was of 31 years of age as per the dates. That's a wrong annexure 6. But in the adoption deed of the year 2012, annexure 3, the age of Bilu Behra was 56.
That is there. Disputed fact. So many disputed facts are there.
Certificate dela balku ote date ta bhule jaye. But Bilu, not the applicant, Dilip Behra, his son, he applied. But unfortunately, he died in the year 2022.
Several facts are
before getting it. My lord, family is in distress. A younger sister, my lord's minor sister, and widow mother is there. So, and admitted fact, my lord's land has been acquired, my lords.
No, that is not in dispute.
So let them.
Your status.
My lords, I have corrected everything in paragraph.
Substantiate your status in the appropriate court of law, then you can get the relief. Otherwise, you cannot.
Yes,
this is not the forum where in the high court you will say all those things. Those are disputed, and we are to adjudicate that. This is not the forum here.
Absolutely no dispute. Your lordship may kindly go through a paragraph. I'm reading, my lords, paragraph 19. All the grounds I have taken there.
So you are justifying the ground. Try to understand. You have tried to justify. What is the question of justification in a writ? So all these things, unless we adjudicate, how can we say that it is proper?
I say that the authority has not considered the.
The authority cannot consider this. These are all matters of dispute.
They have issued a Hindu law adoption. My lords may kindly see that. How they're just throwing out. They should take endeavor to give employment to the land house. Instead of that, the Lord may kindly come to paragraph 60 that they have rejected, saying that the Hindu Adoption Act says that's not correct, my lords. Paragraph H of the impugn order. Apart from above, the adopted deed executed by the extant is not a valid one, as it is violating the clause 10 of the Adoption and Maintenance Act 1956. My lord, 1956 Act says that who will be given in adoption. So at least, my lords, I have made out a case for a notice, my lord. What I'll get or not get, that's a different thing. But the poor family can be survived, my lords. The father expired and there is no breadwinner, my lords. So he is in a distress. Only notice they can consider, my lords. If your lordship direct, they can consider also. That
Which is
those are
your
not,
earlier writ petition order?
that is Annexure 11, 12.
No,
I'm
Annexure
sorry,
11.
11. Sorry. Annexure 12, Annexure 12, your lordship has said that you file a detail considering the limited, my lords, what is my lords? Says, considering the limited nature of prayer and the submission made, this court direct that that in the event the petitioner makes a representation to the opposite part number 2, enclosing a copy of this petition within 4 weeks from today, the same shall be disposed of within a period. Well, that disposal is not correct. That's why I'm praying for a notice, my lord. Your lordship may say that no, whatever they say is correct. So, khali koi doju the maintenance. Your lordship may kindly see that maintenance. What they say that above this age they shall not be given in adoption.
Mr. Mishra, you just take that whatever the order has been passed is reiterated before this court in the counter. What will happen? Whether this court again can go into it in any case. So why should we issue notice?
They may not come.
This should be the counter. This should be the counter their case. Alright, this writ petition has been filed by
But that is not correct, my lords.
Kumar Behera for passing Annexure 13
and 9 also.
the
and 9.
Annexure Annexure 9 ta first record
9.
Annexure 9, which is the order dated later dated so and so, and Annexure 13, which is the order dated so and so passed. It seems that the subparagraph case petitioner earlier approached this court in WPC number 23585 of 2024, wherein it was his case that a representation has been filed by the petitioner before the authority to provide him employment under the LR policy, but the detailed particulars are not mentioned, for which the Learning Council for the petitioner sought permission to file a fresh representation before the General Manager, Hingula Area, Mahanadi Coalfield, and accordingly the writ petition was disposed of as per order dated 1/10/2024, permitting the petitioner to make a representation before the opposite party number 2, enclosing a copy of the writ petition, which is to be disposed of, giving opportunity of personal hearing to the petitioner and the result of the decision taken on the representation to be communicated to the petitioner. The Learning Council for the petitioner submits that in terms of the order dated 1/10/2024, a fresh representation along with the copy of the writ petition was filed, and personal hearing was also afforded by the authority to the petitioner. However, the claim of the petitioner was rejected, which is impugned in this writ petition. On perusal of the impugned order dated 4/12/2024 under Annexure 3, it appears that the opposite party number, General Manager, opposite party number 2, has given the following reasons for rejecting the claim of the petitioner. Quote paragraph E ru quote kar do. E ru pura nahi asantu up to last for example representation of so and so. After the Learning Council for the petitioner drew the attention of this court to paragraph number 17 onwards of the writ petition to submit that the rejection order under Annexure 313 was not justified and proper, and therefore the same is liable to be set aside. However, we find that the authorities found that the deed of adoption and the relevant document filed by the petitioner are contrary and inconsistent with each other. Moreover, the petitioner has not approached the appropriate court for obtaining
Declaration
declaration
with respect to his status
with respect to the status of the petitioner
as adopted.
As an adopted son of Fontana of the deceased. Dilip Kumar Behera. In view of after hearing the land counsel for the petitioner, we do not find any infirmity or illegality in the impugned order, which is accordingly dismissed. It is up to the petitioner to seek for appropriate remedy in the court of law and thereafter seek necessary relief in accordance with the law. Yes, disposed of. Next.
Item 9.
Next. Petition raised for directing the opposite party, particular opposite party number 1, to disperse the claim amount of compensation as the land acquired by the opposite party number 1.
Where is the documentary evidence that your land has been acquired and you are entitled to compensation? Which authority on what date acquired your land?
I'm challenging Annexure 8. Everything is there.
Annexure 8.
8.
This is really a reference case. So, what order was passed?
It was passed that 50% of the compensation amount will be withheld, and it will be disposed to other persons.
Which is the operative part of the order?
Page 66 में लॉस में कम. Ultimately, the reference is partly allowed. Second subparameter, page 66.
Page 66.
Second subparameter.
Yes.
Ultimately, the reference is partly allowed on contest with the above observation. The OP number 3 is entitled to get 50% of total compensation.
This petitioner is the opposite party number 3 there. Okay.
76 lakhs 40,044 rupees for case acquired land, that is measuring acre 0.129 decimals of khata number 178, plot number 1028, classification Puratana Patita of Moja Sampur, within 3 months of passing this award. Otherwise, the OP number 1 is at liberty to implement its 50% award amount along with 9% annum interest by taking the recourse of law. The petitioner will bear the cost of proceeding. However, my lords, under section 74 of the 2013 Act, against this order, an appeal lies to the Honorable High Court.
Against order of reference, is appeal.
Appeal lies. So this writ
74.
My lord.
Okay. Appeal to the High Court.
Yes. Because it's challenging
the authority. Yes, Land and Council. You are to prefer an appeal before this court in terms of section 74 of 2013 Act. And the time limit is also there, that is to be heard within expeditiously within 6 months. So we are disposing of giving you liberty to file the appeal, and that appeal is to be preferred within 60 days. And when your 28/10/2024, of course, there is a provision that you can file a condonation of delay application if it is beyond that period. So you can take this reason that inadvertently you file this writ petition. All right, listen. The writ application has been filed. For a direction to the opposite party to receive adequate compensation along with 100% claim it seems that the petitioner is aggrieved by the order passed by the presiding officer LAR and R authority Patar dated 28/10/2024 in LA reference case number 3 of 2021, wherein it has been held while allowing the reference partly that the petitioner is entitled to get so and so the keen operative part. The Learning Council for the state has pointed out that against the impunity award, the appeal under section 74 lies to this court, and therefore, since alternative remedy is available to the petitioner, this writ petition is not maintainable. Section 74 reads as follows. Quote the section 74. The Land Council for the petitioner, in view of the submission made by the Land Council for the state, and particularly in view of the provision under section 74 of the 2013 Act, seeks permission of this court to withdraw the writ petition to approach to file an appeal in accordance with law. Accordingly, the writ petition is disposed. Yes, sir. There is no, you have a right, statutory right to prefer an appeal, and you can file a limitation petition because that period of 60 days is already over. Right?
Yes.
Item 10.
May I please, Lordship? Mr. 1 is pending before opposite party number 3, my lord.
What is your representation? For what you have filed this representation?
My lord?
Yes. For what purpose you have filed the representation?
Consideration for under OGLS Act, my lord.
This is the type of application. There is a
proper application, my lord.
There is a proper form in which you are to file.
And that part also there is no acknowledgement they have received or no receipt.
There is a Mr. Counsel, if you apply for lease of the land, there is a proper form in which there are so many particulars you are required to be given, and this document which you have filed as your representation, the Learning Council for the state submits that there is no document or no endorsement of the authority that you have submitted this representation. So if suppose of tomorrow you file a contempt petition that the direction was issued, and maybe that no such representation will be available with the Tahsildar, and you will face a contempt proceeding of this court.
So if a proper application is made, then your case will be considered.
We are disposing of that. Let a proper application be made. It is up to the authority to consider the same in accordance with law.
Right, my lord.
This writ petition has been filed by the petitioner Vikram Kumar Pradhan for a direction to the opposite parties to consider the representation dated 11/1/2025 as per the provisions of OGLS Act 1972. जो फॉर्मेटटा तो जो अच्छी टिके देखैले तार गोटे फॉर्म अछि फॉर्म गोटे अछि फॉर्म 1 ना कोन गोटे एटा तो settlement of rule 5(2). The Learning Council for the state raised preliminary objection that the representation cannot be considered by the authority because there is a prescribed form under the OGLS rules 1983 in which the petitioner can approach the authority seeking relief for settlement of the land, and moreover, there is no endorsement of the that about the representation being acknowledged by the concerned authority, nor there is anything that it was sent by post, because the in absence of the postal receipt. Um, in view of such preliminary objection raised by the Land Council for the state, the Land Council for the petitioner seeks permission to withdraw this petition to approach the authority in proper form, seeking relief as prayed for in this writ petition. Accordingly, the writ petition is disposed of.
Obliged, my lord.
Item 11.
Please, Your Worship. An application to condone the delay in filing the review application before the Learned Central Administrative Tribunal, having been rejected, this writ application has been
Which is that order?
And that order is at page
Annexure 13.
46, my lord, Annexure 13.
Annexure 13. Who is to appear for the, you say, railways, who is appearing?
My lord, the central government is, I think there is no separate.
No. Who is to, somebody should.
This is I am.
Okay, we are setting.
I have already filed my application. My name is there, my lord.
Rupesh Kumar Kanungo?
Yes, my lord.
Okay. So, yes, Mr. Misra.
My lord. Here, my lord, the petitioner before your lordship.
Please come to paragraph number 4 of that order.
My lord.
He has quoted the rules in page number 46 or 47. 47 paragraph.
47, your lordship, paragraph 4, your lordship.
Please place that.
Section 17 of the CAT procedure rules, 1987 is very specific.
Yes.
Very specific and deals with regard to filing of review petition. The said provision prescribes that no application for review shall be entertained unless it is filed within 30 days from the date of receipt of the copy of the order sought to be reviewed. Law is also well defined by Honorable Apex Court in the case of Swansea, year 1960, page 220, that the sufficient cause means appellant's explanation for delay has to cover the whole period of delay. Ground put forth by the applicant regarding restriction imposed due to COVID-19 is not well convincing, as the period of restriction due to COVID-19 was from 15/3/2020 till 20/2/2022. Misapplication number 21 of 2022 in miscase application number 665 of 2021 in suo motu writ petition number 3 of 2020 dated 10/1/2022. Hence, this tribunal find that there is undue delay in approaching this tribunal with no proper explanation. Further, admittedly, the applicant filed review application by diary number 85 of 2019, which was dismissed without any liberty. Since the applicant did not show any interest to remove the defect, at this stage, we are reminded by the decision of the law laid down by the Honorable Apex Court that successive review application against the original judgment is not maintainable, and it would be sufficient to place reliance in one such decision of the Honorable Supreme Court in Swansea, wherein in paragraph 36 it was held that set of review applications were nothing. Second set of review applications were nothing short of an abuse of process of court and ought not to have been rejected by the court as not maintainable. In view of the facts and law discussed above, we do not find any reason furnished by the Learned Counsel for the applicant for condonation delay in filing this array as a plausible reason to condone the delay, and accordingly the array is dismissed.
So there is no dispute that the review petition is to be filed within
30 days.
30 days.
My,
So when the main original application was disposed of?
my original application, your lordship, was disposed of. There is
That is again subsequent to the direction issued by this court.
much obliged. The application was filed that remained in defect. There was a deemed peremptory order that if the defect is not removed, then the case will be dismissed. By virtue of that deemed order, the case got dismissed. An application
Because defect was not removed.
defect could not be removed, your lordship. But thereafter, what has happened? An application for recall was filed.
Yes.
When the application for recall was filed, there was a difficulty there also, but the conducting counsel went to the judicial side also, and there was a communication gap by the petitioner, of course. I will not say anything else than the fault of the petitioner. But that application for recall was disposed of. I beg to draw my lord's kind attention to page.
Yes, in that
Annex 12.
in that order also you have been given an opportunity to file the RA.
Yes,
and you have filed the RA. Basing on that, yes.
And my humble submission is the previous RA was dismissed for default for want of removal of defect, not on merit. And this IA that was filed for recall was disposed of saying how page 46, however, considering the prayer of the learned counsel for the applicant for granting liberty to approach this tribunal in appropriate proceeding, it is ordered that the applicant shall be at liberty to pursue his grievance in accordance with law. So after my respectful submission, this is a case of my lord, he was in a job. As my lord, your lordship may kindly see the conditions. My entire endeavor is only for a merit hearing on merit. He was a caretaker to at the Railway Institute, Qatar. Then they had my lord, an advertisement that
if Mr. Mishra, suppose your original application was disposed of on merit, you could have approached this court in writ petition.
That I filed, madam.
Right, we are come. So you approach this court. Then why you again file that review petition?
A review petition of the reasonable court granted me liberty at page 42, your lordship.
Page 42,
my lord was pointing out that
on 13/12/2018, in our considered view, the appropriate remedy for the petitioner is to approach this CAT for that relief by way of review.
Much okay.
And that only basing on that you filed the review, but certain defects were there, we did not review.
And there was a deemed dismissal order, for which reason at page 43, my lord, annex 11, the case got dismissed.
Okay.
But the order was passed by the Honorable High Court in the year 2018. They have preferred an appeal, preferred the review petition and dice number in the year 2019. As per the registry decided to remove the defect. Last 5 years they have not removed the defect. Even if this Honorable Court has granted liberty to file an RA within a period of 30 days.
That is serious.
Then again that was
that is number as included 14. The number as RA number 10 of 2024.
You see the purpose for which this period has been prescribed by in the statute, Mr. Mishra. It is 1 month, and if in this way we will allow it to be entertained, the review petition, then the entire object of the statute will be frustrated. If you file a review petition after 5 years, when the
I didn't file it after 5 months.
No. You see, 18 order kale this court has
13/12/2018.
18. You passed it in 2019. Did not remove the defect.
I filed it on 15/1/2019. That is right. Within 15-20 days.
All right, but did not remove
15-20 days.
After defect remove kale.
Defect remove
that's rahigala pore se order pass hegala se case dismiss hela for non compliance of the tapre then you filed an interim application perhaps to recall the order.
Misapplication for recalling the order. The court was of the view that you cannot file a misapplication, you have to file a fresh review. So that is why liberty was granted.
Where is that misapplication order?
Misapplication order is at page 34, annex 12 here only. While touching upon the merit, page 45, the court in paragraph 5, the learned tribunal granted liberty. Only thing there are some kind of, I will not say that he was very vigilant, but the difficulty is this is a very, very small job, my lord, where.
What was your main prayer in that
regulation? Absorption. Your main prayer was for to absorb.
Absorb, because there was a dispute as to whether I have joined in 97 or 2004. The board held that no, you have joined 2004, 97. So therefore, to requisite experience for observing. But he could have continued as a caretaker also. And there was.
You have been removed from the
long. He is not in a caretaker, man. But that totally out of job, your lordship.
So,
pauper, my lord. I will not draw for sympathy. I will only pray, my lord. I am praying for a consideration on merits, my lord.
There was no justification against
some kind of
matter. Here
some kind of comparison in the matter.
He has made a submission that let me file the you ଯେତେବେଳେ court ରେ inclined ହେଇନଥିବେ merit ରେ ଗୋଟେ review petition file କରିକି ନେଇକିନି
No, in fact, I was conducting, I remember, my lord, when I conducted, the Honorable Court was pleased to ask me a question that is reflected in paragraph 2, page 42. That did you raise these points for the Central Administrative Tribunal? When I said no, then the court said, Your Lordship, kindly, the point which has been made out here for payment of so and so was not argued for the Central Administrative Tribunal. Therefore, the demand for, therefore, the observation for filing review.
This decision which has been quoted in the impugned order regarding the second review petition, what has been stated there? Is it a case where it was disposed of earlier on merit?
Or it was on merit.
They stated that it was abuse of process.
It was on merit. Unfortunately, my lord, I find the engaging counsel, though it was brought, my lord, has left it. I would have given because I had made copies.
So we have to see that if it may be so that the first review application was disposed of on merit,
yes,
and then the second review.
That is the situation.
But
I have to. I am unable to show it. I was just asking.
No.
I'll show it.
That would be the distinction between the two decisions.
Your Lordship may take up next week. I'll assist you. My entire endeavor, my lord, in this case is only if we can get some grace of your Lordship, my lord.
Mr. Shamik, Municipal and Senior Advocate, appearing for the petitioner, and Mr. Rupesh Kumar Kanungo, Land Central Government Council. After arguing for some time, the Land Council, Land Senior seeks for an adjournment till next week to substantiate his argument that the decision of the Honorable Supreme Court in the case of S. Madhusudan Reddy versus E. Narayana Reddy and others, 2022 SCC Online SC 1034, on which reliance has been placed by the Land Central Administrative Tribunal while passing the impugned order, is factually different than this case. Put up this matter in the week commencing from 3rd of March 2027. Yes, grateful, Vice. Grateful.
Item 12.
I have filed IA number 3287 of 2025 for the amendment of the read petition.
Which one?
IA number. It is not tagged.
What is the IA?
For amendment of the read.
No. Please tell us the number so that it will be.
IA number 3287.
3287 of 25. For amendment of the read petition. All right. What is your good name?
Srinivas Satpathy.
Mr. Srinivas Satpathy, Land Council, appearing for the petitioner, submits that an interim application by IA number 3287 of 2025 has been filed for amendment of the writ petition. Stop. You have received the copy. Let a copy of the interim application be served on the Land Council for the state. Matter will be placed next week along with IA number 3287 of 2025.
Item 13.
On the order, that is 2524 mile. And next one is many operating part.
Order complaint?
2524.
Mile.
Annexure 1.
Mile.
It was not complied.
Mile.
The disposal of the representation.
Mile.
Give us the certificate copy.
Certificate copy, my lord. I have sent the annexure 2, my lord. 15524 mile.
15.
I have not taken.
Where is the certificate copy along with that?
Certificate copy annexure 1, my lord. Annexure 2 is my representation along with the certificate copy. Just I am sending your lordship. After they receive my order, my lord, they have convened a meeting, my lord. Since my lord have not taken any action, only.
Okay, they have acted upon you.
2824 mile issue notice to the villagers, my lord, Yeah, the convening meeting for
So
They have to complete it.
you obtain the instruction, Mr.
ITCO is a private party, man. So you
Who is
notice
the-
may issue, man.
Oh, it goes Mr. Mahanti.
Sarosh Kumar Sethi. Acha. All right. This contempt petition has been filed by the petitioner for non-compliance of the order dated 2/5/24.
Petitioners, man. For petitioner.
Petitioners for non-compliance of the order dated. Writ petition ne eman samaste thile. Order dated 2/5/2024 passed in WPC number 26320 of 2019. It appears from the aforesaid order dated 2/5/2024 that this court, without expressing any opinion on the merits of the case, disposed of the writ petition, directing the opposite party number 4. Opposite party number 4 ki hai? ITCO authorities to consider and dispose of the representation filed by the petitioner, while Annexure 5 annexed to the said writ petition, and to pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. The London Council for the petitioner submitted that the copy of the order dated 2/5/2024 was served on the opposite opposite party contemner on 15/5/2024. 15/5/2024. After receipt of the order, though the opposite party has formed for changes,
issue notice to the ledger 2/8/24.
Need notice kahaku ichi?
ଆମ ସମସ୍ତଙ୍କୁ ହେଇଛି 12%.
Has issued notice to the petitioners.
ଆମେ ଉପରେ 4 ଜଣ ଅଛୁ. 1 2
ଏ contempt petition ରେ ତ ଅଛନ୍ତି ସମୁଦାୟ 4 ଜଣ.
2 3 4 5 ମେଲ୍. ଆମେ ହଉଛୁ 2 3 4 5.
And others and others fixing for hearing.
ତଳେ ମୋ ରିପିଟିସନ ଟା ଅଛି, ନମ୍ବରଟା ଅଛି.
11/8 ରେ appear କରିଥିଲେ?
ମେଲ୍
12/8 ରେ appear କଲେ?
2 ହଁ ଆଜ୍ଞା.
କଣ ହେଲା?
ସେମାନେ କହିଲେ ଆମେ
ତାପରେ ଆଉ କିଛି ଆସିନି?
ଆଉ କିଛି କରିବୁ ଆମେ କରିବୁ. ମେଲ୍ ଆଇ ହାଭ୍ ରିସିଭ୍ ମାଇ
ଫାଇନାଲ ରିଜଲ୍ଟ ଟା ଆସିନି?
ଘର ଜାଗା ପଇସା ନେଇଯାଇଛି, ଖାଲି ଜାଗାଟା ଆଲୋଟ କରିବା କଥା କରୁନାହାନ୍ତି.
And issued notice to the petitioner and others. And on the date fixing for hearing, and on the date fixed, though the petitioners and others, the petitioners approach the authority, but the final decision with regarding the representation of the petitioners are yet to be taken off. Issue notice to the opposite party, requisite for issuance of notice be filed within a week. Matter will issue after 3 weeks. Yeah. Only.
Item 14.
Yes, Mr. Bera.
Instruction.
My lord, the petitioner was noticed for hearing.
Status of LAR case number 29 of 2011.
My lord.
On that you are supposed to obtain instruction.
Yes, my lord.
It also case now.
Yes.
On instruction only.
The hearing ହେଇଯାଇଛି 28 a application ର hearing
2 months for
hearing ହେଇଥିଲା 13/2/2023.
Achha.
Thereafter, today I have received a letter from the Department of Water Resources Department. They are taking 3 month time to implement that.
No, ଏଥିରେ ଲେଖେଇଛି ଆପଣ 2 ମାସ ସମୟ ଦରକାର ସେ ଯୋଉ ଡିସ୍ପୋଜାଲ ପାଇଁ। 21/2 ଆପଣଙ୍କୁ ଆମକୁ ଯୋଉଟା ହ୍ୟାଣ୍ଡ ଓଭର କଲେ ତେଣୁ
ନେକ୍ସଟ ଚିଠିଟା ତାକୁ ନୋଟିସ ହେଇଥିଲା ପିଟିସନରକୁ ତାର
13/2/2025 ରେ
ହିୟରିଂ ପାଇଁ
କାଗଜ ପତ୍ର ଦବା ପାଇଁ କୁହାଯାଇଛି।
ଆଜ୍ଞା ସେଟା ହେଇଯାଇଛି। thereafter water resource department has issued sanction କରିବେ inter department
ଏଇଟା ତାପରେ
24/2/2020
the compensation have been listed once the orders of the respective have to be implemented in later. However, implementation order may require in more time from the legal. Eta hala kit number eta implementation number
132
132. So request that allow 3 months time. Disposal 11. In terms of the order dated 11/2/2025, the Land Council for the state has produced data dated 21/2/2025 of a special LA and RRO Lower Indra irrigation project Kariyar, wherein it appears that for hearing of the matter, notice has been issued to the parties and 2 months time was sought for to dispose of the LAR case number 29/2011. Another letter dated so 24/2/2025 of Director RR Additional Secretary of the Government has also been produced by the Land Council for the state, wherein it is mentioned that the order of this court has to be implemented in letter and spirit, and the implementation of the order requires some more time for in view of interdepartmental movement of the file. Accordingly, 3 months time was sought for in the case of the petitioner for sanction and implementation of the order. Both the letters dated 21/2/2025 and 24/2/2025 are taken on record. In view of the instruction obtained by the Land Council for the petitioner, we dispose of the contempt petition, giving 3 months further time to the authorities. That is opposite party number K 2.
opposite party number 3.
3.
Both are
on he carry out kariyo apan
opposite now carry out the order passed by the opposite party number 2 year 1 year
opposite party number 2 को
2 percent
अच्छा 1 and 2 बोली तो
yes 1 and 2
parties कर दो carry out the order within a period of 3 months है from today कर दो from today the order free copy of the order be handed over to the Land Council for the state, which will be communicated to the concerned authority for compliance. Yes.
Item 14.
Item 15 तो same है.
Same.
7 no, ठीक है what out कर दिया.
15 same order. अपन सेटा देखते तो प्रथम ना. সেই টাইপর এটা দেখিয়ে লেগে তাদের
opposite parties
সেম অপোজিট পার্টি সে 3 মাস দিয়ে দেবে ডিসপোজ অফ প্রবলেম
17 and 18 too
16
ନାଇଁ
16
ଦୁଇଟା
16 ଟା ଦିଅନ୍ତୁ ଡକ୍ୟୁମେଣ୍ଟ ଅଲଗା ଅଲଗା ଡକ୍ୟୁମେଣ୍ଟ ଦଉଛନ୍ତି ତ କେସ୍ ନମ୍ବର ଗୁଡା ପଡି ହଁ ତାକୁ ଦେଖିକି ଲେଖିବି
ଏଥିରେ ଅଲରେଡି ଆୱାର୍ଡ ଦେଇଯାଇ ତାକୁ ଚିଠି ହେଇକି ରିସିଭ୍ କରିବା
ହଁ ତାହେଲେ ସେଟା ଡିସପୋଜ ଅଫ ହେଇଗଲା ଦେଖନ୍ତୁ ଏଇଟା ଲେଖି ଦିଅନ୍ତୁ this is item number 16 this contempt petition has been filed for non-compliance of the order dated 2/7/2024 of this court passed in WPC number 15498 of 2024, the London Council for the State has produced the written instruction received from the Special LA and RRO, Lower Indra Irrigation Project Hariyar, wherein it is mentioned
last page 6/2/2025. Notice dated 6/2/2025 and by
that the petitioner
13/2/2025 document
He was directed to appear.
See, the petitioner was directed to appear and receive the sanction decretal amount, right? The sanction decretal amount. The letters are taken on record. Letters along with the notice issued to the petitioner are taken on record. In view of such documents filed by the Land Council for the state, the writ petition, the content petition disposed of. Yes.
Item 17.
Satra number ta kaun?
In this case, the enhanced proposal, enhanced amount already sent to the government, calculation sheet. Last page. Time release कर दो.
That means action has already been initiated in compliance.
Yes. Last page calculation.
Calculation sheet kari. Eta kaku submit ହେଇଛି?
Submit ହେଇଛି eta director R&R, ex-officio additional secretary, water resource department.
This content petition has been filed by the petitioner.
My lord, thereafter, OP1 is directed to dissolve the repetition. After the
order here, the honor for non-compliance of the order dated P10/2024 passed by this court in WPC number 24507 of 2024. The Land Council for the State has produced the written instruction received from the
Special Land Acquisition.
Special Land Acquisition Officer, so and so, lower in the which in also carries a calculation sheet of the decretal dues and the same is stated to have been forwarded to the Director RR and ex officio Additional Secretary to Government Department of Water Resources, Odisha, Bhubaneswar. And the Land Council for the State submits that 3 months time may be granted for taking
sanction and release
for sanction and release of the decretal award amount in favor of the
11%.
In view of such, the documents are taken on record. In view of the documents produced, the content petition is disposed of. Yes. 18.
Item 18.
18 minor. Notice was issued to the petitioner for hearing on 20A application. That is on 25/10/2024. And it is found that the allegation in the information is correct. And they have already in person to kind person to the kind of the order court. Order dated 3/10/2024 in WPC number so and so. The repetition filed by the petition for disposal of the repetition submitted under section 20 of the Land Action Act has been verified and found correct. The petition has been accepted by this office. Accordingly, notice has been issued for hearing as required under section 2 of section 28 of the LA Act to the petitioner, all other person having interest in the land, hide office PR number
କେତେଦିନ ସମୟ
Compliance is in process.
compliance ତ
comply ହେଇଛି କି?
comply ହେଇନି, comply ଟା partly ହେଇଛି ନା, ଆପଣ accept କରିଦେଲେ but ଆପଣଙ୍କୁ କହିଲା ଯେ dispose of କରିକି decision ଟା ତାକୁ ଦେବେ 3 ମାସ ଭିତରେ, so in that way there is non-compliance according to him. You have no doubt you have taken steps in terms of the order, but it has not been completely carried out. So, when the date was fixed for?
Date was fixed for hearing 7/11/2024.
7/11/24 ତ ଗଲାଣି, ସେ ପୁରୁଣା ଇଏ ତାପରେ କଣ ହେଲା ଆପଣ?
ତାପରେ ଦେଇନାହାନ୍ତି, pilot may kindly examine the matter or direct the authority to dispose.
No, the thing is that you have complied the order, that is not correct. How can you comply this? ଆପଣ dispose of କଲେ ଯାଇକି representation ତାକୁ order communicate କଲେ ଯାଇ compliance ହବ. ଆପଣ ଯଦି ଖାଲି notice ଟା issue କଲେ for hearing, that would not be the.
Then my lord, 1 week after I will tell you.
Because 4 months almost 4 months are passed.
This contempt petition has been filed by the petitioner Shobhan Sagaria for non-compliance of the order of this court dated 3/10/2024, passed in WPC number 24513 of 2024, wherein direction was issued to the opposite party number 2, the Special Land Acquisition Officer Lower Indra Irrigation Project, Hariyar Nuapada, to take a decision on the petition filed by the petitioner under Annexure 2 annexed to the said writ petition, and to pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order, and to communicate the result of the decision taken thereon to the petitioner within a period of 2 weeks. The Land Council for the state has produced the written instruction dated 21/2/2025 of this Special LA and RRO Lower Indra Irrigation Project, Hariyar, which indicates that the notice has been issued for hearing as required under subsection 2 of section 28A of the LA Act 1894 to the petitioner and all other persons having interest in the land. And the copy of the notice dated 25/10/2024 has also been annexed to the said letter dated 21/2/2025. However, in the operative part of the letter, it is mentioned that the order dated 3/10/2024 of this court has been complied with. In fact, we are of the view that merely issuing the notice to the petitioner is not the compliance of the order dated 3/10/2024. The authority concerned has to take a final decision as per the aforesaid order dated 3/10/2024 and to communicate the result of the decision, which is yet to be done. The Land Council for the state seeks some further time to obtain further instruction in the matter, put up this matter in the week commencing from 17th March 2025. This is taken on record. They're just coming within 2 minutes.
Item number 19. That's item 19. I am on behalf of Mr. Dhananjay Mode. I may be permitted to withdraw.
Withdraw.
Item number 20.
May it please, my lord, I am appearing in VC. I'm also permitted to withdraw, my lord. IA that has been filed at flag X for recalling of the order. I may be permitted to withdraw.
I am Soma Patnaik, Land Counsel, appearing for the petitioner, seeks permission to withdraw the IA later dispose of it, disposed of a all.
Grateful.
Item number 21.
Item number IA 20. You have taken on record for this memo. Yes, Miss Mishra.
May I please, Your Lordship, this is for amendment, my lord. ସେଟା did not ବୋଲି ଲେଖିଦେଇଛି prayer portion ରେ ସେଇଟା ହିଁ ଭୁଲ ହେଇଯାଉଛି ମୋର ଆଜ୍ଞା prayer portion ରେ in the read petition actually the land has allotted on the basis of the sarpanch letter which is my allegation my lord. That is in my
schedule incorporate habo
ମାତ୍ର ସେତିକି ଏଇ ଯେ
କୋଉ portion
prayer portion
ରେ
ଆଜ୍ଞା
Court
prayer portion to show cause as to why they did not allot the land as per the এটা পুরা change ହେଇଯାଉଛି ଭିତର
ଆଚ୍ଛା
ସେଇପାଇଁ why they allot the land
ଠିକ ଅଛି ଯେ so who are the opposite parties here?
The state, my lord.
Tahsildar and collector.
My lord.
So yes, Mr. Naik,
I have already
received
given
the copy. Any objection? Formal. IN number so on. So there is an application for amendment for incorporating incorporating or the prayer portion for them. पूरा prayer portion टा को change करके ना इटा को incorporate इटा को करीबे अच्छा the land council for the state has received the copy of the interim application and submits that he has no objection if the
prayer portion first paragraph टा हाँ वो rejoinder भी दे दीजिए
And the counter is in rights period.
अच्छा এটা prayer portion no first paragraph আচ্ছা যেটা দেখুন prayer portion no first paragraph পাই this amendment is necessary he has no objection accordingly interim application is allowed the schedule portion shall now form the part of the first paragraph of the prayer portion of the writ petition the consolidated writ petition shall be. Have you filed it or got to file it?
Amendment petition filed.
Amendment memo?
Consolidated.
You give a copy also to him. Consolidated writ petition copy incorporating this one so shall be amendment of portion shall be filed within 1 week. Within 1 week, giving copy to the land council for the state. Yes. Amendment regarding the counter. You have already filed counter.
Yes,
already filed counter. The land council for the state submits that since counter affidavit has already been filed, he may be given liberty to file further affidavit, counter affidavit, if necessary, in view of the change in the prayer portion. All right. Permission is granted. Yes.
My lord, hearing the answer.
ଆପଣ କରନ୍ତୁ ଆଜ୍ଞା କନସୋଲିଡେଟେଡ୍ ରିଟ୍ ପିଟିସନ୍ ଟା ଆସୁ ଅନ୍ ରେକର୍ଡ ହେଲା ତାପରେ ୟେସ୍ ଆଇଏଟା ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେବେ
Consolidated, huh? Item 22.
Pardon me, Lordship, I am in DC, Lordship. Lordship, there is an IA for a modification of the order dated 21/1/2025. Lordship, my representation was pending before the collector and district magistrate Kalahandi, opposite party number 3. It was inadvertently mentioned in the order that representation before the opposite party number 2 revenue divisional commissioner was
So in
mentioned.
place of 2, it should be 3.
Yes, my lord.
Your representation in the writ petition is dated 23/2024.
Yes, my lord.
Which is that representation? Let us see.
Annex 5, your lordship.
Annexure 5.
এটা তো আরডিসি କୁ ଲେଖା ହେଇଥିଲା।
ଲେଖା ହେଇଛି। ଆରଡିସି କୁ ଲେଖା ହେଇଛି ଏବଂ ଅର୍ଡର ମଧ୍ୟ ଆରଡିସି କୁ ହେଇଛି। ଆଉ ଅସୁବିଧା କଣ ହେଲା?
Lordship, my representation was given to Tahsildar and copy forwarded to.
The council, please come to that representation, which is at page 47, annexure 5, that is addressed to the RDC. So how, and we have passed the order that RDC is to dispose of the representation. Now you are saying that my representation should be disposed of by the collector. For collector, there is no representation. How can we pass such a direction? If there is no representation filed before the collector, then how the collector will dispose of the representation?
Lordship, I think by mistake.
By mistake, you withdraw. This is not. This cannot be solved in the in an interim application. You are at liberty to file a fresh representation before the appropriate authority, and if it is delayed, then you can file another writ petition.
Lordship.
IA number so and so. This is a modification of the order dated so and so. After going through the interim application, we do not find any reason to modify the order dated 21/2/2025. Accordingly, the IA is dismissed.
Item 23.
May I please, Lord? Sir, the IA is for amendment of the writ petition. By way of this amendment, the petitioner wants to bring the justification by virtue of which his land has been acquired. That was not there. So averment was made, but that notification was not available.
No, it's all right. Who are the opposite parties?
Opposite parties, my lord, they are the co-sharers. And they
no, this matter, you see, whether notice has been issued, notice has not been issued.
No notice has been.
So at least state has is on record. So let him I hear a copy देवें क्या?
I have a copy. कॉपी दिया है 21 तारीख दिया है
देखो वेरीफाई कर दें
दे दिया
I would a copy दे दिया तो give it during course of the day or by tomorrow you give it
in course of day
देखो IA number this is 3198 ना 3198 of 2025. This is an application for amendment of the petition. Let a copy of the interim application be served on the land council for the state during course of the day. Matters will be listed next week for consideration of the interim application.
Next also same. That is 3199. I number 3199.
All right. Same order next week.
Item 25.
Just a minute. Mr. Otho,
yes,
since these are hearing matters and this is not the irregular bench, we'll take up this matter tomorrow.
Tomorrow,
all these final disposal matters.
Yes, ma'am.
Because
I know this is not the regular.
No,
Yes, ma'am.
So, Mr. Nayak and
maybe parking to get to mention.
This case petitioner is in
That's page 4 of the lordship first list, item 12 notes. In that case, my lords, I received the spare copy of the result affidavit filed by my senior lords. Lord, and this is a case for Lord, existence application having been rejected. So my senior has filed a petition once. And my Lord, in this case, I filed the counter. Today, I get a spare copy of that counter, result affidavit. It will come in some of the things, both ways.
You tell both of us, both of you tell what are they. But it should be concluded, it's not.
It should be finished here.
Let us take it up next Monday or Tuesday, anything. Get prepared, don't take time. Mr. Sangram Das and Senior Standing Counsel for the Vigilance 6 for an adjournment. On what ground you are seeking for adjournment?
I'm grateful to my Lord Senior when getting their spare copy of the result affidavit.
I submit that he has received the result affidavit copy to the counter affidavit filed by the Vigilance Department and wants to go through the same, and that will be taken out next week on some other day. Is this matter on 4th of March 2025. Mr. Ashok Mantil and Senior Advocate for the petition is present. Yes.
Interim arrangement to continue. Adjournment.
Continue till next week. Yes.
Milan, this petitioner is in custody more than 10 years. So kindly be.
Please give it. Item number 12, CRLMP 1245 of 24.
Criminal appeal hearing. Criminal appeal hearing.
Criminal appeal. Who was wrong?
2016.
Jail criminal appeal.
Criminal appeal.
Notice, I don't know what CRL 683 by 23.
That he has 2 sons.
Yes. What is your IN number?
607.
607 of 25.
Elder father, late in October.
Father's elder brother.
This appellant, see elder father.
अरे किए मोला किए नटवर महंत तो से आपेलांटर कौन हेबे
बड़ बापा
सिया तो कहूँ बड़ बापा हेले नि फादर सेल्डर सिया तो कहूँ कौन इंस्ट्रक्शन नेले को
Notable Mahanta has 2 sons, namely Charan Mahanta, 56 years, and Koresh Chandra Mahanta, 3 daughters. They are married. Petitioner is the son of Banshidhar Mahanta. Banshidhar Mahanta has 2 sons, the present petitioner and another Niranjan Mahanta. Now Niranjan Mahanta is taking care of the family of the present petitioner. The presence of the petitioner.
So there are many persons according to you.
आंकर तो पुओ अछि
दवा ପାଇଁ ଜିନିଷଟା ଇମ୍ୟୁନିଟି ଗ୍ରାଉଣ୍ଡ ଯିବା ପାଇଁ
मंडा हेबे
ହଁ 2 ସପ୍ତାହ ହେଲେ ବି ସେ କାଫି ସେ କଣ୍ଟାକ୍ଟ କରୁଥିଲେ ମତେ 2 ସପ୍ତାହ
फैमिली मेंबर बापाटा मरिछि और कोन ते कोठिकार घर कोठी
घर आगे
कौन एक केस कौन
केस आगे
हार्डन क्रिमिनल नहीं तो
Simply.
नहीं मुगु की एंती ये
no antigen as per my instruction antigen
Family member and tailor.
Number 607 of 2025. There is an application for interim bail on the ground that elder father, bracket example, father's elder brother of the petitioner, namely Notable Mohanto, expired on 17 to 2025. And in order to perform the obsequious ceremony, the presence of the petitioner is necessary. Land Council for the state has produced the written instructions received from officer in charge of Moronda Police Station, which is as follows. Quote for the proprietary program. Considering the submission made by the Land Council for the respective parties, the governments taken in the interim application, the written instruction received by the Land Council for the state on humanitarian ground, we are inclined to release the petitioners on interim bail for a period of 2 weeks. While on bail, shall not indulge in any criminal activities, shall not leave the jurisdiction of the Land and Trial Court.
Urgent certificate copy. Yes, in course of the
ଆପଣ ଦିଅନ୍ତୁ ଆପ୍ଲାଏ କଲେ ଆମେ ଗଲେ ସିନା 10 ମାରିକି ଦବ ଆଉ କଣ? Yes.
Petitioner to file the surrender certificate.
Surrender certificate date fix up. Yes.
Quickly list item number 1.
May appellant convicted under section 302 34 IPC and sentenced to undergo RI for life and a pay of fine of rupees 20,000.
Fresh admission.
That's it.
Alright, Art admit call for the trial court record, interim application for bail and stay relation of crime to be considered after receipt of the trial court record. Deposition copy to be supplied to the Land Council for the state and in the meantime. Yes.
Item 2. Wait, please, my wife. That's the appellant herein has been convicted under section 302 by 34 IPC and he has been convicted for life with fine of rupees 30,000.
Same order, admit. Yes.
Item 3.
Pardon, item 2 has the instruction to appear for the informant.
Do nothing.
I'm fine.
ଅଛି ଓକାଲତ କାହିଁକି ଆଉ କଣ ଯେବେ ଜାଣିକି ତ ଆଡମିଟ ହେଲା ଆଉ କଣ ନା ଆଡମିସନ ହବାକୁ ବି ଅବଜେକ୍ସନ କରିବେ।
Item 3 before item 3 proceed. They pray for Monday only because they
କଣ ହେଇଛି?
ଆରଥରକ Mr. Prabhu Prasanna Behera was there and he stated that he don't have the file. But today is also the same condition.
I'll pay copy. Pen drive I will receive a copy. Maybe can
last occasion he took time.
ମନା କରୁନାହାନ୍ତି ଆପଣ ପେନ୍ ଡ୍ରାଇଭରେ
Monday
ଏଟା କଣ ପାଇଁ ଆସିଛି ବେଲ୍ ପାଇଁ? IN number 279 of 2024. This is an application for bail. The Land Council for the State 6 permission and to take the deposition copy of the witnesses from the trial court record on its pen drive. Permission is granted. The registry shall supply the same to the Land Council for this. The foot of this matter next week as well. Next one, foot of this matter we commenting from March 2025. Uttar Pradesh Arijit Mishra Land Council for the appellant is present. Yes.
Item 4.
The appellant is husband and order dated 18 to Ordinary into their direction to provide the deposition purpose. Already short
So ଆପଣଙ୍କ ଅଫିସ ଯଦି ସାମିଲ ନ କରିବ ତାହେଲେ କଣ କରାଯିବ? ତାଙ୍କ ପାଖରେ ତ ରସିଦ ଅଛି ଆଉ ଆପଣଙ୍କର ଅଫିସର ରସିଦ ସେ ସପ୍ଲାଏ ହେଇଛି ଆଉ ଦି ଡ୍ୟୁଟିଜ ୱିଚ ଯିଏ ତାକୁ ରଖୁଛି ଆଉ ସାମିଲ କରୁନି ତାଙ୍କୁ ପଚାରିବେ ନା ଆଉ ତାଙ୍କୁ କହିଲେ ଆଉ କେତେ ଥର ସେ ଆପଣଙ୍କୁ କପି ଦେବେ?
paper Monday. College.
The Land Council for the Appellant submission that to ask for the order dated 18/2/2025. He has already supplied the deposition copies of the witnesses in the AG office and the receipt is available with him. But the Land Council for the state submits that the deposition copies have not been tagged to the file and the matter may be taken up next week. Please, this matter will be commencing from 3rd March 2025. Yes.
Item 5.
Next week. Mr. Council and Council appealing for the appearances for an agenda. The higher lecture, bail court. Yes, next week.
Item 6.
I am moving bail.
Yes.
I am moving bail for appellant number 1. As per the request made by the legal aid, that the petitioner number 1.
I have filed for 4 other appellants, CRL number 259 of 2025.
Could I
have filed for other 4 appellants in the same judgment. The case number CRL 259 of 2025.
CRL
259 of 2025.
259 of 24.
25.
25. That has been admitted.
Now all the cases have been admitted.
No. This is not admitted.
Admission ହେଇନି admission ହେଇନି ତ memo ଦଉନାହାନ୍ତି admission ପାଇଁ ଆସିବ
actually
ଆପଣ informant ପାଇଁ ନୁହନ୍ତି ତ
informant ପାଇଁ
appellant
other
appellant
ଆପଣ ଯୋଉ criminal appeal ଟି file କରିଛନ୍ତି admission ହେଲା ନା ନାହିଁ
admission
ହେଇନି ତ memo ଦେଲେ admission ପାଇଁ ଆସିବ. Why are you creating hurdles in the moving of the bail application of these appellants? କଣ ଆପଣ ଚାହୁଁଛନ୍ତି ଏକାଠି ଶୁଣାଣି ହବ ଆପଣଙ୍କ admission ହବ ତାପରେ ସେଟା orders ରେ ଆସିବ ଏକାଠି ଚାହୁଁଛନ୍ତି ଶୁଣାଣି ହବା ପାଇଁ ମେମୋଟେ ଦିଅନ୍ତୁ ତାହେଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଲେଖିକି ଦିଅନ୍ତୁ ମେମୋଟାକୁ ଲିଷ୍ଟ କରିଦବ ନେକ୍ସଟ ୱିକ ରେ ହେଲା along with ପଳେଇ ଆସିବ ଏଗୁଡା
ନାଇଁ ମୋରଟା ଆଜ୍ଞା ଯୋଉ ସ୍ପେଶାଲ କ୍ୟାମ୍ପେନ ହେଇଛି ସେଇଥିରେ ମୁଁ ଖାଲି ଫାଇଲ କରିଛି on merit malot in one appeal 5
ସେଟା ସେଇ କେସ୍ ଟା କି
5% who have been murdered
ଯାଇଥିଲା ଲେଡିଜ ଗୁଡାଙ୍କୁ ଦେଇଥିଲୁ
ଦେଇଥିଲେ ଏଇଟାରେ ଆଜ୍ଞା ଯୋଉ ଲିଗାଲ ଏଡ୍ ର ଗୋଟେ କ୍ୟାମ୍ପେନ ହଉଛି ନାଲସାର ଇଏ ଅନୁସାରେ
ଆମେ ଦେଇଥିଲୁ 5ଟା ମର୍ଡରରେ ଆସୁ ଏଟା ନେକ୍ସଟ ୱିକ
ଏଇଟା ଦେଇନାହାନ୍ତି ଏଟାରେ
ନାଇଁ ଆମେ ପୁରା ଦେଇଥିଲୁ I think we gave that bail.
ସେଇଟା ହଉଛି ଲେଡି ମାନଙ୍କ ପାଇଁ
ସେଇ ତ ଲେଡି
ଦେଇଥିଲେ ଏଇଟା ହଉଛି ଆଜ୍ଞା ସେ 84 years old ଏଇ ଯୋଉ ସ୍ପେଶାଲ କ୍ୟାମ୍ପେନ ହେଇଛି ଯେ
ନେକ୍ସଟ
ଫେବୃଆରୀ
ସେ ଜଜମେଣ୍ଟ ଟା ବି ଷ୍ଟଡି କରିବା ଦେଖିବା
ନାଇଁ ଜଜମେଣ୍ଟ ମୁଁ ଆଜ୍ଞା ଖାଲି ଦେଇଛି ଆନେକ୍ସ କରିଛି ଲିଗାଲ ଏଡ୍ ଯୋଉ ଚିଠିଟା ଆସିଛି ଲିଗାଲ ଏଡ୍ ଯୋଉ ଚିଠିଟା ଆସିଛି
କଣଟା ତ ଦେଖିବା
ଖାଲି ଏଜ ଅର ଏଲିଂ ସେଇଟା ଆଜ୍ଞା ଦେଇଛନ୍ତି କି ସେମାନେ ଚିଠିଟା ଦେଇଥିଲେ ମୁଁ ସେ ଚିଠିଟା
at that time
ଏଇଟା ସ୍ପେଶାଲ କ୍ୟାମ୍ପେନ
ये सदाशिव माझी सदाशिव माझी was 70 years at the time
70 years ନୁହେଁ ଆଜ୍ଞା ସେଇ ନା 80 କେତେ ହେଲାଣି ଏନକ୍ୱାରି କରିକି କରିଛନ୍ତି 80 କେତେ years ଲିଗାଲ ଏଡ୍ ବାଲା
ଦେଖି କଣ
ସେଟା ଆଜ୍ଞା କରିଛନ୍ତି 28 ଏପ୍ରିଲ ଭିତରେ 28 ଫେବୃଆରୀ ଭିତରେ ଇଏ କରିବାକୁ ନାଲସାର
but is it for us
କଣ ଏଇଟା
ସେ ତାଙ୍କର ଗୋଟେ ଇଏ କରି ଆପଣ
ଅଛନ୍ତି ପୁରା ନିଜେ
ନ୍ୟାସନାଲ ଲିଗାଲ ସର୍ଭିସେସ୍ ନ୍ୟୁ ଦିଲ୍ଲୀ
ଏ ଯୋଉ ଇଏ କରିଛନ୍ତି ଯୋଉଟା ପେଣ୍ଡିଂ ରହିଯାଇଛି ବର୍ତ୍ତମାନ ଏଜ ବେଶୀ ଅଛି
ଗୋଟେ ସ୍ପେଶାଲ କ୍ୟାମ୍ପେନ କରିଛନ୍ତି
A amicus curiae has been appointed in that case also. The matter has been fixed to next month, 24th or something, in Supreme Court.
So there is no such order. It out and kind of year.
ନାଇଁ ସେଇ ସ୍ପେଶାଲ କ୍ୟାମ୍ପେନ ଅନୁସାରେ ଲିଗାଲ ଏଡ୍ ଗୋଟେ ଚିଠି କଲେ ମତେ।
ଦେଖିବା next. Yes.
ମୁଁ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଆମେ ଫାଇଲ କରିଛୁ, ନହେଲେ ତ ବେଲ୍ ରେଗୁଲାର ବେଲ୍ ଟା ଅଛି।
Item 7. May please, my lord.
Yes.
My lord, there are two appealants before my lord.
Appellant Virupaksha Panda and Rinku Sahu.
My lord.
You Bela interim application number which is 2673
My lord.
of 24. एटा दी जन ପାଇଁ फाइल करचंदी।
No, my lord. The IA has been filed for only Virupaksha, my lord.
No.
And another
ଅଛି ଏବଂ petitioners ଲେଖିଛନ୍ତି ବେଲ୍ ଆପ୍ଲିକେସନ ନି ଆଉ ଜଣ ପାଇଁ କଣ କରୁଛନ୍ତି? If you intend to file interim application for only one,
no, my
then
lord. This is the main bill.
Madam, please come to the interim application. ଆମେ ଆପଣଙ୍କ interim application ଦେଖି ହିଁ କହୁଛୁ।
My lord.
ଏଣ୍ଟାର ଉପରେ ତ ପିଟିସନର୍ସ ଲେଖା ହେଇଛି, ତଳେ ଯେତିକ ପାରାଗ୍ରାଫ ଅଛି ଆପଣ ଲେଖୁଛନ୍ତି ପିଟିସନର୍ସ ଟେକେନ୍ ଇନଟୁ କଷ୍ଟଡି, ପିଟିସନର୍ସ want to, and petitioners therefore may be released on bail. Petitioners obviously means ଦି ଜଣ ଉପରେ ଲେଖିଛନ୍ତି and another. ତେଣୁ ଆପଣ ଏଇ ପିଟିସନ ଟା କେମିତି କହୁଛନ୍ତି ଜଣଙ୍କ ପାଇଁ ଫାଇଲ କରୁଛନ୍ତି? ବୁଝିଲେ? ତାକୁ ୱିଡ୍ର କରିନିଅନ୍ତୁ। ଯଦି ଚାହୁଁଛନ୍ତି ଆଇଏ ଫାଇଲ କରିବାକୁ କେବଳ ଜଣଙ୍କ ପାଇଁ, you file another application. ବିରୁପାକ୍ଷ ପଣ୍ଡା ପାଇଁ ଚାହୁଁଛନ୍ତି ତ ମୁଭ୍ କରିବା ପାଇଁ? କଣ ଅସୁବିଧା କଣ ହଉଛି ମୁଁ ବୁଝିପାରୁନି।
Application IA number 2673, my lord.
IA number 2673.
That is what we see.
That is
And another.
application.
And another.
ଆପଣ
We are there for both the
For both.
ସବୁଥିରେ ଏବଂ ପାରାଗ୍ରାଫ ଗୁଡାକ ମଧ୍ୟ ଦେଖନ୍ତୁ ସବୁଠି ଲେଖିଛନ୍ତି ଆପଣ ପିଟିସନର୍ସ ଏବଂ ପ୍ରେୟାର ବି ମଧ୍ୟ ହଉଛି ପିଟିସନର୍ସ ରିଲିଜଡ ଅନ୍ ବେଲ୍। ତେଣୁ ସେଇଥିପାଇଁ ପଚାରୁଛୁ ଯେ ଆପଣ ଗୋଟିଏ ପିଟିସନର କେମିତି କହୁଛନ୍ତି? ଆମେ ପଚାରିଲୁ ସେଇଥିପାଇଁ ଜଣଙ୍କ ପାଇଁ ନା ଦି ଜଣ ପାଇଁ ଆପଣ କହୁଛନ୍ତି ଏଇଟା ଫାଇଲ ହେଇଛି ଦି ଜଣଙ୍କ ପାଇଁ, but you are moving for one.
For both.
For both.
Moving for both. both ହେଲେ ଠିକ ହବ। So you are moving bail application for both the petition. All right. So what is the conviction?
My lord, the conviction is under section 302 by 34 IPC, my lords.
Okay. So what is the prosecution case come to that paragraph number 2?
My lords. My lords, the prosecution case is that the present the first appellant, that is
Please come to the paragraph number 2 of the judgment. Please place it.
Shown the unnecessary details, the prosecution case is that one Nandu Rohindas, the uncle of the informant, had borrowed money, fertilizers and seeds from the accused Virupaksha Panda of first camp for cultivation. On 4/1/2017, at about 6 p.m., one Pintu Maji of Gujatal came and asked said Nandu Rohindas for payment. The uncle of the informant promised him to make payment on later date. On that day, at about 6:30 p.m., said Pintu, along with Rinku Sahu and Virupaksha Panda, arrived there and searched the uncle of the informant, found him near the mango tree and quarreled with him. At that time, the aunt of the informant, namely Tapaswini Rohindas, called the informant on hearing Hulla, and both of them went to the spot. Nandu Rohindas fled away from the spot, and at that time, the accused person chased him, caught hold of him near the house of Pina Rohindas, and assaulted him by means of sharp cutting weapon and threw him in the field. After assault, the accused person fled away from the spot by a motorcycle and an Activa. The mother of the informant, namely Bhuta Rohindas, has seen the incident. After the incident, the informant and her aunt went to the spot and shifted Nandu Rohindas to Bulla Hospital for treatment. During the course of treatment, the doctor declared the said Nandu Rohindas as dead. On 4/1/2017, the informant, namely Rinki Rohindas, presented a written report before the inspector in charge, Hirakut PS, and the said case was registered as PS case number 2 of 17.
So, as it appears that there are eyewitnesses to
My
the
lords.
occurrence. Who are the eyewitnesses?
PW3, 11, and 14. My lords.
Just a minute. PW3, PW
11,
11,
and PW 14.
and who is the doctor who conducted postmortem examination?
My lords, the doctor PW 10.
You first come to the PW 10. Let us see. How many blows you have given? No. You are not spared from the right from the top to bottom. Eyewitnesses have stated implicated both the appellants.
My lords, PW3 has stated, and 11, my lords.
They have implicated that both the appellants assaulted the deceased
My lords.
by sharp cutting weapon.
My lords, omnibus allegations have been made.
That is really.
And my lords, PW11, who is the wife of the deceased, she has not been cited as a charge sheet witness and nor was examined during the investigation. And she has directly been charge sheet, brought to trial during as an eyewitness.
These are the things which are to be appreciated at the time of trial. But after all, 3 eyewitnesses are now dealing against both of you. That how you have assaulted
It's not supported, my lords.
No.
PW14.
One witness if supports and the court believes that witness, then this quality is material, not the quantity. And doctor has stated you have given as many as 13 40 injuries, both of you, and right from the body, skull was found once. How many years you are in custody?
My lords, have been in custody since
17.
6/1/2017.
It's not that.
This my lord, court cases and
Are the learning counsel for the petitioners?
The question, my lords, is not that somebody is in custody or not.
Yes.
My submission, my lords, is this. If your lordship will see the judgment,
yes,
I would ask your lordship kindly to look at paragraph 8, my lords.
Yes.
Where he has discussed the informant's judgment.
It's all right. We are not going into the merits of the case now. We are not hearing the appeal. The 3 statements are there. The medical version is there, and you are in custody for 7 years. That we are considering. Whether you may have a case for acquittal ultimately.
No, I am not asking for that. I am asking for bail during the pendency of the
Yes, yes. That we are.
So if your lordship wants, I'll prepare a chart of the evidence. Your lordship can go through that and then.
Not necessary. Heard the land counsel for the petition, land counsel for the state. In view of the eyewitnesses' account of PW3, 11, and PW10, and the evidence of the doctor, bracketary PW10, who has noticed as many as 13 spot injuries in different parts of the body of the deceased, among with us, and the opined that the cause of death is so and so. And the submission of the land counsel for the state that the appellant number 1 is having 4 criminal antecedents and the appellant number 2 is having 3 criminal antecedents. We are not inclined to release the petitioners on bail. Stands rejected. Still realization of fine. Yes.
Your lordship may only note that they were on bail during the trial.
The land counsel for this one also submit that they were on bail during the trial. Yes.
Item 8.
This appeal has been posted today for admission. It's
how much delay is there?
107 days. Let's say.
the stamp reporting देखिएगा stamp reporting 165 days and it's a 302 case. Life imprisonment. IN number so on. So this is an application for condonation of bill. The stamp reporter has pointed out that there is delay of 165 days in filing this criminal appeal after hearing the learned counsel for both the parties and going through the amendments taken in the interim application. And since the appellant has been sentenced to imprisonment for life, we are inclined to condone the delay in filing this criminal appeal. Accordingly, delay is condoned. Heart admit call for the trial court report. Is there any interim application for bail and stay realization of fine to be considered after receipt of the trial court report? Deposition copies to be supplied to them. Yes.
Item 9.
Same connected matter.
Tari? No. Same order. That there be delay of 5.8 days.
One.
Dita alga alga na kama?
Two same case रे दिजन trial face करना है এবং ডিলে আচ্ছা ডিলেটা একা ডিলে আছে 165 দিন ঠিক আছে তাদের भी সেই অর্ডার করে দেবে ডিলে কোনো অ্যাডমিট yes
Item 10.
Item 10 IN number 45445
কেতে দিন ডিলে আছে 121 302 case
302 life imprisonment
all right
Sir, 181 delay 121
हाँ डिलेटा करियो 121 और से जो टाइप का ऑर्डर है से टाइप को करिए डिले कॉन्डोन करिए एडमिट कर देबे कॉल फॉर द ट्रायल कोर्ट रिपोर्ट अपन आदर बेल एप्लीकेशन और ये अच्छी स्टे अच्छी that is to be considered of the trial court deposition copy to be supplied. Yes.
Item 11.
11 my lord, I am on virtual mode. Roman 1 is jail criminal appeal my lord. Second is mine.
Just a minute. In item number, the first item is JCRLA 4 of 2024. Yes, Gautam ki. Am I to see?
Yes, Gautam and the amicus curiae to assist the court.
Yes, Gautam ki. ଆପଣ ଜାଣିନାହାନ୍ତି ଏନଗେଜ କରିଛନ୍ତି ଏସ୍ ଗୌତମ ହଁ ନାଇଁ ଅଛି ଯେ ତା ଦେହରେ କଣ ସିଏସ୍ ଗୌତମ ଲେଖିଥିଲା ନାଇଁ ନା କିଛି ସେ ଲେଖିନି
He wanted an assistant.
ହଁ ସିଏ ଆସିଷ୍ଟାଣ୍ଟ କଲା ଇଏ ଏସ୍ ଗୌତମ କିଏ ସିଏ
The court has also not gone into the business.
No.
Amicus curiae calling.
Amicus curiae calling. ନାଇଁ ମୁଁ ଦେଖୁଥିଲି ବା ତାପରେ ସେ appear ବି କରୁନାହାନ୍ତି
Name has been appeared in the name to reflect
ନେମ୍ ରିଫ୍ଲେକ୍ଟ ହେଇଛି ସେମିତି ମାନେ ସେଇ ଟାଇପ ର ମାନେ ଜଷ୍ଟ ନା ହେଇ ଚାଲିଛି ବଟ୍ ଆଉ ଗୋଟେ କରିଦେବା ସେ ପ୍ୟାନେଲ ଏଇ ପ୍ୟାନେଲ୍ସ ଦେଇଛନ୍ତି ସାର୍ ସବୁ ଦେଖିକି କରିଦେବା ଅଛି ନା ପ୍ୟାନେଲ Yes.
So for second item is concerned, Sub-item is concerned, I may indulge your lordship's attention, your lordship's order dated 7/1/2025. My associate was doing his mother passed away, therefore I'm not well versed. But it may be for limitation, 37 day limitation. The order dated 7/1/2025.
Let an affidavit be filed by the father of the victim who received a notice stating about offense was that.
No.
POCSO.
ନାଇଁ ନୋଟିସ ହେଲା ଯେ ସିଏ ତ ତା ବାପା ନୋଟିସ ରିସିଭ କଲେ ଆଫିଡେଭିଟ ପୁଣି ଆଫିଡେଭିଟ କିଏ ସିଏ ତ ମଧ୍ୟପ୍ରଦେଶରେ ରହୁଛି ନା
Father of the victim, as the victim is staying at her in-laws place at Madhya Pradesh. Let an affidavit be filed by the father of the victim who received notice stating about the knowledge of the victim. It is within the knowledge of the about the case, but she cannot. Father कौन दबा सर?
Father कौन दबा?
Major अच्छी.
The order dated 7/1/2025 has been filed. Non appears for the informant oblique victim version. Informant কি আছে? Trial court record আসছে না? একটু লেখাই দাও judgment
Dated 6/3/2025.
Informant alleged victim. এটা informant আচ্ছা যে victim ছাড় দেন informant/victim what is the how much delay is there, Mr. Misro?
37 days now.
IN number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 37 days in filing this criminal appeal. Since after hearing the land and counsel for both the parties, Mr. Mistral and senior advocate and Mr. Nayak and additional government advocate, and since the appellant has been sentenced to life imprisonment, we are inclined to condone the delay in filing the appeal. Accordingly, delay is condoned. Hard admit call for the trial court record. What further application you have filed?
For stay of fine of 50,000.
And only still.
Why?
IN number 735 of 2024.
735.
Compensation. Compensation.
This is the implementation of life and to pay.
Mr. Misro, 735 is for that is what is this? Condone the delay. That we have condoned.
Condone the delay is valid IN number 308. I'm sorry. I'm just giving that.
So far the affidavit part is concerned.
IA is one.
Already there.
That is
okay.
Document name.
Lordship is right now.
In terms of this one, so affidavit has been filed for them. Hello.
In case of violation of fine amount, this sum shall be forwarded to the victim as compensation.
ये तो बापा तो mentioning therein that he has already communicated the notice to the victim. The affidavit is taken on record. ସେଟାକୁ ଅନ୍ୟ ଗୁଡା ସେଗୁଡା ରହିବ ଯୋଉ ନନ୍ ଆପିୟସ୍ କରିଦେଇକି ସେଗୁଡା ରହିବ କରିଦେଇକି ବାକି ଯାହା ଅର୍ଡର Mr. Mishra, there are two interim applications. One is for condonation of delay. We have condoned the delay and we have also admitted the appeal. Trial court record has been called for. What further you want?
516 of 2024.
516 for what purpose you have filed?
That stay operation of the fine, my lord.
Or stay realization of fine, okay.
Yes, ma'am.
Okay, so let the trial court record come. We'll consider it, the interim application for stay realization of fine to be considered after receipt of the trial court record.
Mobilize.
चेयरमैन भी जो अशोक महांती जो एडजमेंट नेले सब जो कल्याण संग्राम सॉरी यादर किसी अच्छी के रेडी छोटो अच्छी because this is not the regular bench, that's why.
Item 15.
Item
15.
15. It is distributed on. It must be down the chapter.
Appellant well-being. Any information has been received about the well-being of the appellant. It has come. He is there.
पुराना फिल्डर काले डेथ ହେଇଥିବ ସେଇଥିପାଇଁ ମଗାଏ नहीं ठीक ଅଛି ସେତିକି କଥା Okay, you place the FIR. Let us see what is the prosecution.
My lord,
ସୁବଲ ଜାନେ ମହାଶୟ
ମହାଶୟ ନିବେଦନ କାରଣ ଏଇକି ମୁଁ ସୁବଲ ଜାନି ପିତା ସାଗର ଜାନି ଗ୍ରାମ ନଗଲେନ୍ଦୁ
Informant कितना नंबर साखी निगोल जो PW1 हाँ पढ़ो
PW1
पढ़ो एफआईआर पढ़ो
ମୁଁ ଖଜୁରୀପଡ଼ା ଜିଲ୍ଲା କନ୍ଧମାଳ ମୋର ଝିଆରୀ କୁମାରୀ ସୁଲକ୍ଷଣୀ ଜାନି ବୟସ 17 ପିତା ଅନ୍ତର୍ଯାମୀ ଜାନି ଗ୍ରାମ ନଗଲେ
ସୁଲକ୍ଷଣା ଜାନି ହେଉଛି କେସର ଡିସିଜ୍ଡ
ମାଇଲ
ଓକେ ହଁ
ଥାନା ଖଜୁରୀପଡା, ଜିଲ୍ଲା କନ୍ଧମାଳ, ଜାତି ଆଦିବାସୀ, କନ୍ଧ ଅଟେ। ଆଜି ଦିନ 11ଟା ସମୟରେ ଜଙ୍ଗଲକୁ ଜାଲ ନେଇ ଯାଇଥିଲା। ଏହି ସମୟରେ ତାଙ୍କୁ ହତ୍ୟା କରି ସୁନା ଗହଣା ଲୁଟି ନେଇ ପଳେଇଛନ୍ତି। ତା ମା ଝିଆରୀ ଫେରିବା
ଝିଅର ଫେରିବ ବିଳମ୍ବ ହେବା
ଖୋଜିବା ପାଇଁ ଗଲା। ସେ ଜଙ୍ଗଲରେ ଝିଅର ମରି ପଡିଥିବା ଶବ ଦେଖିବାକୁ ପାଇଲା। ତାପରେ ଏ ବିଷୟ ଆମେ ଜାଣିବାକୁ ପାଇଲୁ। ଏଣୁ ଏହାର ତଦନ୍ତ କରି ସୁବିଚାର କରି ଦୋଷୀଙ୍କୁ ଦୃଢ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କଲେ ମୁଁ ଆପଣଙ୍କ ନିକଟରେ ଚିର ଉପକୃତ ହେବି।
FIR ହେଲା direct evidence na circumstantial evidence?
Only PW5 is the eyewitness. On the basis of
सीधा PW5.
I know the deceased, so also the accused. Occurrence took place 2 years back. That day, myself, Sukanti and Sadhavani, alias Pudi, had gone to Boradi Mundia for.
ये माने किए सुकांती और साधवाणी ये माने किए साक्षी ଦେଇଛନ୍ତି सुकांती और साधवाणी they have never been examined. They have not been examined. ସିଏ ଯାଇଥିଲା ତା ସାଙ୍ଗରେ ଆଉ ଦି ଜଣ ଯାଇଥିଲେ ଯୋଉମାନେ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି। ଆପଣ had been to.
This had gone to Tolomba hill to collect firewood. We were about 60 cubic away from the deceased. At about 10 a.m., I heard the cry raised by the deceased shouting, "Mitu Hanidala." In this case, Mitu is the upland man. We all three rushed towards the deceased. From a distance, we saw the accused giving blow to the deceased with an axe. Seeing us, the accused threatened us to giving out that if we told anything against him, he would lie us. He would kill us. Out of fear, we came back, and we did not venture to tell anybody about what we had seen. The Mundia oblique hill was full with bushes and trees. Both the hills situated side by side. Standing inside one hill, one would not be able to see the other hills. We four went together, but on the way proceed towards Tolomba, and we towards Boradi. Both the hills situated adjoining. I cannot give the duration of time between in deceased departing us the cry and the cry raised by her. We saw the accused chasing the deceased and giving blows. The deceased was found running away not towards the road but into the hill. We saw them from there behind. Near around the spot, there were no trees or no bushes. Or bushes. There were no obstruction between us and the place of assault public chase.
I interrogated.
Paragraph 4. I was interrogated about 6 days after the incident. Before that, I had not disclosed this fact before anyone. It is not a fact that I have not seen the accused chasing, assaulting, assaulting the deceased, that I have not heard any cry of the deceased, and that the accused had not given threatening to me. 6. Danda Jatra was to commence from the occurrence day. The accused had participated in Danda of village Sunaponga, where from the police arrested him. It is not a fact that from the previous day the accused had left village of Sunaponga to take part of to take part in Danda, and he participated in Danda from 1st to 14th of the calendar month. It is not a fact that we had not seen the accused in the hill, and that being tutored by presentation, I depose against him, and that I have strong suspicion that that the accused might have committed the crime.
ये witness केबे examine हला police पाखरे 6 days
6 days after my letter.
date of occurrence होची केबे 4/1/2027
4/1/2005
1/4
ମାଇଲ
এটা 2/4 ରେ ତାକୁ ଏକ୍ସାମ ନେଇଛି on the very next day.
ସାବିତ୍ରୀ
ନାଇଁ ଏଇଟା ହଉଛି ସୁଗଲ ମୁଗଲ
ସାବିତ୍ରୀ
ସାବିତ୍ରୀ
PW 5 होची ସାବିତ୍ରୀ
PW 5
PW 5
ସାବିତ୍ରୀ
16 witness तो
हाँ ସାବିତ୍ରୀ ହେଲା ସାତବର୍ଣ୍ଣୀ ସାବିତ୍ରୀ ସୁକାନ୍ତି ସାବିତ୍ରୀ ହେଇକି ସେ ଆଜି
पेज केते
ଏଇଟା ହେଲା
36 35
ନାଇଁ
ଏଇଟା ମୁଁ LCR ଟା କରୁଛି
हाँ ये पेज होची 226 सावित्री जानी এটা एग्जामिन
ଆଜି 2/4
7/4 अच्छा 7 ହେଲେ ଘଟଣାଟା ହେଲା
1/4
1/4 date of occurrence 1/4/2005 PW 5 exam 07/04/2005 accused के बारे में
13/4
if he has not
उन्नीस he is in custody 14 years 2 months. He is in custody 14 years 2 months.
Is there any other evidence?
ସେ ୟାର କିଛି ଅଛି ସେ ଯୋଉ 27 ର କିଛି ମାନେ ଅଛି
କଣ କହୁଛି କଣ ଆମର
While the carpenter, while in custody, he told that he had thrown the deceased gold earring into the jungle and had concealed the wedding apparatus on his wall in his house.
wearing apparel ତାର କଣ ଯାଇଛି SFSL
Examination is very scanty manner.
ନାଇଁ କାହାର ୱେରିଂ ଆପେରାଲ ତା ନିଜର
ଦଶଟା ଅଛି
accused brought his କାରଣ ଇଏ ତ ମାରିଲା ତାଙ୍କ ଏଭିଡେନ୍ସ ହଉଛି ପଳେଇଲା ତ ଗୋଟେ gold earring he had thrown the accused deceased gold earring gold earring କେତେବେଳେ ତାର ନେଲା ସେ ଯୋଉ ଆଇ ୱିଟନେସ୍ ଭର୍ସନ ଟା ହଉଛି ଆସିଲା ତ ମାରିଲା ପଳେଇଲା ଧମକ ଦେଇକି the gold earring would have got
Judgment has mentioned they were in he was
they were in love
to be married with him. That was he was a difference in opinion. When the some mother whom the accused was very liking was the misbehavior, then out of that anger it has committed. That case 4 it has mentioned during investigation. It is came to light that page 4. Perhaps internal page 2 of the judgment.
Next, ଆପଣଙ୍କର 27 ରେ ଯୋଉ ବାହାରିଲା ଆପଣ କହୁଛନ୍ତି କଣଟା ଗୋଟେ ହଉଛି ତାର ଗୋଟେ ପେୟାର ଗୋଲ୍ଡ ଇୟରିଂ ବାହାରିଲା ଆଉ ଗୋଟେ ହଉଛି କଣ ନିଜର ସେଟା ହଉଛି କୋ ସିଜର ଲିଷ୍ଟ କେତେ ଏକ୍ସିବିଟ୍ 8 11 ନା 11 ଟା ହଉଛି ଷ୍ଟେଟମେଣ୍ଟ ଟା 27 ଷ୍ଟେଟମେଣ୍ଟ ଟା ହଉଛି ଏକ୍ସିବିଟ୍ 11 ଲେଖା ହେଇଛି ଆଉ ଏକ୍ସିବିଟ୍ 8 ହଉଛି ବୋଧେ ଏକ୍ସିବିଟ୍ 8 ଟା ଦେଖି ଏକ୍ସିବିଟ୍ 8 ଟା ହଉଛି ହଁ ଗୋଟେ ପୁରୁଣା ପଲିଷ୍ଟର ଲୁଙ୍ଗି ଯାହିଁରେ ରକ୍ତ ଦାଗ ଲାଗିଥାଏ କମଳା ରଙ୍ଗର କ୍ରସ୍ ଚେକ୍ ପଡିଥିବା ସୂତା ଗାମୁଛା ସ୍ୱାଣ୍ଡସୁ ହାଫ୍ ସାର୍ଟ ଏଥିରେ ତ କିଛି ଗୋଲ୍ଡ ରିଙ୍ଗ କଥା ନାହିଁ ଏଟା ଖାଲି ତା ଲୁଗାପଟା ଯାହା ଗୋଲ୍ଡ ରିଙ୍ଗ ୱାଟ୍ ନେଭର ପୋଲିସ ହେଫାଜତରେ ଥାଇ ତାର ଏତିକି ଦେଲା ବୋଲି ଲେଖା ହେଇଛି ତାର ଯୋଉ ବ୍ଲଡ ଷ୍ଟ୍ରେନ୍
no opinion as to group
ଆଚ୍ଛା
କେବଳ ହ୍ୟୁମାନ ଅଛି no opinion
ବାକି ଏ ଯୋଉ ଗୋଲ୍ଡ ଇୟରିଂ ଟାର କେତେ ସିଜର ଲିଷ୍ଟ କେତେ
Caesar second accused could not pointed out the exact place where he had thrown the ornament.
ବାବା ମାନେ ରିକଭରି ହେଲା
In that offense, 379 IPC has already been acquitted. At the time of
oh he also faced trial under section 379 and he has been acquitted.
Only 302.
So who are the other witnesses? Because as we find from the trial court record, 13 witnesses were examined by the prosecution. So PW5 is an eyewitness to the occurrence. ଅନ୍ୟମାନଙ୍କ ବିଷୟରେ କିଛି material witness ଅଛନ୍ତି?
Only hearsay, man.
Since the prosecution examined only one witness, and that's eyewitness.
Eyewitness. So ଆପଣଙ୍କର submission କଣ? Conviction ଉପରେ ଆପଣ ଯୋଉ ହେଇଛି what is your points?
Statement of witnesses each other manner.
Statement not supported by
statement not supporting the prosecution.
Clearly କୁହନ୍ତୁ କଣ ହେଇଛି? ଆମେ ଏଇ ଯୋଉ 5 ନମ୍ବର ସାକ୍ଷୀଟାକୁ କାହିଁକି ଡିସବିଲିଭ କରିବୁ?
PW13 and the statement of PW5, the heels are adjacent to each other.
PW?
As per the statement of PW13 and the PW5, the deceased went to another hill and the eyewitness went to another hill as per their statement.
Yes.
And the from the statement of the two witnesses, PW5 and 13, it is
13
IO has stated that the heels are standing to adjacent to each other.
Hills are standing adjacent to each other, but the geographical situation is that it is only 60 cubits. That has not been demolished.
And the hills are bushes and
spot nahi. Ye kuchi, ayo kuchi, bushes. What is the extent of bushes?
Se goes no, se five college near around this.
Na seiti nahi, ayo roku.
5 भी कोई no trees around this.
Nahi कोई तो.
No. Near around this spot there was no tree or bushes. So even in 6 cubit it is not impossible to sue a person.
Para 5. The spot is Mundia called Bundli. Bandi Mundia hill is 50 meters away from Bundli hill. The hills are covered by sal trees and bushy jungle. There is a pathway leading to one hill to another. Near the dead body, some fresh cut branches were lying.
ମାନେ ଜେନେରାଲ କ୍ୱେଶ୍ଚିନ୍ ଜଙ୍ଗଲ ଅଛି ଇଏ ଅଛି ସିଏ ଅଛି କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଆଇ ୱିଟନେସ୍ ମାନଙ୍କର ପୋଜିସନ ଆଉ ଯୋଉ ଜାଗାରେ ଘଟଣା ହେଲା ୟା ଭିତରେ ଏମିତି
though the informant as well as the alleged eyewitness are same villager, but till 7 days they have never disclosed before anybody.
ଧମକ ଦେଇଥିଲା
But at the relevant time he was at Jatra. The statement of the PW5, he was in Danda Jatra. The accused was not in the village.
Danda Jatra kuade?
Say Danda Jatra
it is the village re na?
Nahi. From outside of the village. Danda Jatra जो हुए दंड जो हुए ସେଥିରେ ଯୋଉ ଏକା ଗୋଟେ ଗାଁରେ ସେମାନେ ବୁଲି ବୁଲିକିରି ନାଚ କରନ୍ତି PW5 para 6 your lordship mechanism. Danda Jatra was commenced from the occurrence date. Accused has participated in Danda of village Sunapanga where the police arrested him. But he was arrested on 13. He was participated in the Danda Jatra.
କେତେବେଳୁ ହବ କଣ
1 ତାରିଖରୁ last part ରେ ଲେଖିଛି Danda Jatra. He had participated in Danda Jatra from 1 to 14 of the calendar month. Danda Jatra ରେ
ଏଇ ଘଟଣାଟା ହେଇଛି ସକାଳ 10ଟା ବେଳେ ସକାଳ 10ଟା ବେଳକୁ ସେ ଦଣ୍ଡ ଯାତ୍ରା ପାଇଁ ବାହାରି ଯାଇଥିବ କି ଘରେ ଥିବ.
alleged eyewitness has never stated even if he was
eyewitness କଣ ତାକୁ ଯାଉଥିଲା ଦଣ୍ଡ ଯାତ୍ରାରେ ତା ସାଙ୍ଗେ ବୁଲିକି ଦେଖିବାକୁ.
He has never disclosed before anybody, and the weapon of offense was not seized from the petitioner.
Weapon of offense?
Tangia. That was lying on the near the spot. But the said eyewitness has never stated that he has thrown the Tangia and ran away from the spot. Rather, he has stated that he proceed towards the top of the hill.
ଆଉ ଇଏ ଟାଙ୍ଗିଆ ସେଠୁ ମିଳିଲା ବୋଲି କିଏ କହୁଛି? ଆଇଓ
No,
MO6 is the Tangia seized by me at from the spot. तो मिस्टर महांती 1 तारिख दिन आपनकर एतलाटा होची जो एतलारे अननोन लोक नारे होची एवं गोटे मर्डर हेगला जंगल भितरे एवं तेबेठू इन्वेस्टिगेशन स्टार्ट ହେଇଗଲା पुलिस विभिन्न लोक पचरा पचरी कर गाँव रे अन्य जगार तार सबुदिन हूँ नो क्लू ये तीनटा साक्षी ये जो साक्षी विटनेस रो स्टेटमेंट हूँ जे आमे मु आउ दीटा साक्षी आमे जाइथिलु जंगल भितर को हठात शुणिलु कौन मालो मरीगली ना कौन ना मिट्टू हाणीदेला बोली शुणिकिना आमे देखिलु देखिला बेलू ये ताकू गोड़े गोड़े हाणुची तापरे आमको जो मिट्टू देखिला कहला तमे जदि क्या कहब मु तो तुमको मारदेवी यह हूँ केस तेणु आम पलि आसिलु सेठू पलि आसी आउ क्या कहवाक आमर साहस पाइलानी जो आम चुपचाप ही रही तो या जदि एविडेंस हुए तो कहीं जानी ना आक्यूज भी रही तो हठात कौन है 7 तारीख दिन केमती से भयटा केमती चलीगला आसिक पुलिस पाखे स्टेटमेंट देदेले
What impaired the witnesses because they have not volunteered? Had they said that as the police was busy in investigation, we now thought it proper to divulge it. That is also not the explanation. What is the clue for the police to examine these three and the volunteers?
से माने जदि कहा कही ना पुलिस रो नॉलेज रे केमती आसिला जे ए तीनटा होचंदी ए केस रो आई विटनेस आसी तांको एग्जामिन कले से मन तो का कही ना अच्छा जदि हाँ अक्यूज्ड धर अरेस्ट हो जाई थांता ताले तांको जो भयटा थिला सेटा चल जाई थांता अक्यूज्ड भी तो अरेस्ट हेनी अक्यूज्ड अरेस्ट हेची जाई 14 तारीख दिन तेणु से माने जो एक्सप्लेनेशन दउचंती रिगार्डिंग नॉन डिस्क्लोजर of the evidence, non-disclosure about the occurrence, how far it is acceptable. The witnesses, eyewitnesses to the occurrence have given a specific explanation as to why they earlier did not disclose about the occurrence before anybody, including to the police, though the police was investigating the matter for last 6 days. Now, the main reason which they are assigned that it was due on account of fear because he has threatened us to kill or threatened me to kill. So if that was the fear psychosis, that was the reason, then how it got dispersed on 7th, how the police came to know about it. मु जदि कहा कहनी मु घटना जानी बोली पुलिस केमती जानिबो जे मु घटना देखी बोली काटू पाइबो
that statement is never disclosed. No clue.
No clue. There is no whisper by the witnesses before anyone that although we know we cannot disclose because there is a threat. It is also not that. And two important witnesses who are together, they have also not been examined.
Those were accompanied with the PW5. If the situation prior to the occurrence could have been brought into the notice, there was a relationship and the proposal marriage of the accused with the deceased.
You see, belated
belated
examination or belated disclosure
is not
of an important witness to the occurrence is very fatal unless the reason comes up. Once the witness does not say anything, once the prosecution does not come up with an explanation as to why the explanation which this witness has offered, that is not believable, that is not acceptable. Because that fear psychosis is still there. The reason which is happening, that is still there. At least हाँ अपन कही पाने मन करंतु 14 तारीख पर से विटनेस टा एग्जामिन होता ताले कही थांते हाँ 14 तारीख से अरेस्ट हेगला तेणु गाँव रे पुलिस बुलिलानी तारा भय रहिलानी तेणु से कहिला पुलिस पाखे किंतु पुलिस जदि आपण कही थांते पुलिस आसिला भय पळेला पुलिस तो आसी 1 तारीख रु इन्वेस्टिगेशन करछि ताले 2 तारीख कोन हला 3 तारीख कोन हला 4 5 6 कोन हला से 7 तारीख काई कहला कही पार था आगु डिस्क्लोज करी पाता तो हठात आपण जेतेबेले नहीं आसुचंती जने विटनेस को आई विटनेस ये हिसाब रे तो आपण को एक्सप्लेन करिवार अछि जे why he made a belated disclosure about the occurrence. You will find so many case laws on that. That was the main reason why these eyewitnesses are being disbelieved. ହେଲା କାରଣ ହଁ ଗୋଟେ ଥାନ୍ତା ଯଦି ଆକ୍ୟୁଜ ଗୋଟେ ହାର୍ଡ ଆଣ୍ଡ କ୍ରିମିନାଲ ହେଇଥାନ୍ତା ଲେଟ୍ ଅସ୍ ସେ ଗୋଟେ ହାର୍ଡ ଆଣ୍ଡ କ୍ରିମିନାଲ ହେଇଥାନ୍ତା ଆରେ ଆକୁ ଇଏ କଲେ ଆମର ତ ଇଏ ହେଇଯିବ ସେମିତି ତ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଇଜ ଏ ନର୍ମାଲ ମ୍ୟାନେଜର କୋ ଭିଲେଜର ତେଣୁ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଗୋଟେ ଡାଉଟ ହଉଛି ଯେ whether these witnesses have been set off afterwards to depose against because the police did not get any clue by three witnesses they have, and that is the reason why two of them have also not supported the prosecution case for perhaps before the public prosecutor, for which he declined to examine them.
But the entire case revolved around the statement of PW5.
Right.
Whatever the statement of PW5 in the initial statement, the cross-examination is elicited developed. That is more pointing more towards the appellant. Cross-examination. The cross-examination that we that the Mitu Handela, we all three lost to the deceased. For distance, we saw absolute giving blow to the deceased with the axe. But in cross-examination, did not discarded these that they have not seen. In cross-examination, they are developed para 3 that the Mundoli hills were full with blossom trees, both the hills situated side by side, standing inside the one hill, one who was not able to see the other hill. We four went there, but on the way to deceased, proceeded toward the Talamba and towards Baradi. Both hills situated adjoining. I cannot give the duration of time between in deceased departure us and cry raised by her. We saw the deceased chasing the deceased and giving blows. In cross-examination, they have brought out the things from their mouth that
it's all right that they have
the deceased was found running away towards the road, but not into the hills. We saw from there behind. Near around the spot, there were no trees and bushes. There were no obstruction between us and the place of assailants. So the statement which he unerringly has stated that he has saw the
Your Lordship may kindly see one thing in the FIR. In the FIR, the informant has stated that the deceased was wearing some gold ornaments. The deceased was wearing some gold ornaments, and the eyewitnesses PW5 had stated that no gold ornament was taken by the accused.
No,
and during investigation, the gold ornament was not with the deceased nor near the place.
No, it was not recovered, for which you have been acquitted under 379. That was the allegation in the FIR that ତାକୁ ହତ୍ୟା କରି ସୁନା ଗହଣା ଲୁଟି ନେଇ ପଳାଇଛି। ଏହା ହେଉଛି ତାଙ୍କର FIR story ଥିଲା, for which you also faced trial under section 379 ହେଲା। କିନ୍ତୁ ଯଦିଓ ତାଙ୍କର allegation ଥିଲା ଯେ ଗୋଟେ କଣ କାନର ଯୋଉ ଇୟରିଂ ଟା ଗୋଟେ ପେୟାର ମିଳିଲା ବୋଲି, ସେମିତି ତ କିଛି ଏଭିଡେନ୍ସ ଆସିଲାନି। ଖାଲି ଗୋଟେ 27 ରେ ଯୋଉଟା ରିକଭରି ହେଇଛି ସେଟା ହଉଛି ବ୍ଲଡ ଷ୍ଟେନ୍ ୱେରିଂ ଆପେରାଲ୍ସ।
That means it was with the deceased. So that is not it.
We saw them from their behind.
No, that is also not very important. The whole thing is that Mr. Mahanti, that is when the court relies on the solitary evidence of an eyewitness must be of sterling quality, free from any kind of.
Not in the front side. We saw them from
so
their.
They know they are villagers. She is close to them. So what? From behind is not the question. One can see from the gesture, posture, they are so close. They can even identify them even if it is a dark. So that is not very.
You are Mr. Jambeshwar Pati. Mr. Jambeshwar Pati, Land Counsel for the appellant. Mr. Aurobindo Mahanti, an additional standing counsel for the state. Hearing is closed, judgment is reserved.
Okay.